right. Welcome to the Zoning Board of Appeals meeting for, oh my goodness, it is Tuesday, August 18th, 2026. I was looking at the wrong date. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. We have today a full agenda and a full room. I'm going to ask everyone to bear with me. I'm going to try to make this happen in a way that is as complete as possible, but also that gets us out before, the sun rises. To start off, we're going to accept minutes from May 26th, June 30th, and July 14th. Is there any comments from folks on those minutes?
I'm abstaining from those since I wasn't there.
All right. Do we have a motion?
I'll make a motion to accept the minutes from May 26th, June 30th, and July 14th, 2026 meetings.
One note, I can abstain as to the last two, at least the last two, but I was here on May 26th, so.
So actually, we may not.
I don't know if we need the vote, but.
How many votes do we need for meeting acceptance? Do we need 3 or do we need 4?
Just a majority.
I think we need
3.
a
Okay.
majority.
Okay. All right. So we have 3 votes. So, all right. So let's do them one at a time, just because we have a slight difference here.
Okay, I make a motion to accept the minutes from May 26th, 2026.
I'll second.
All in favor?
Aye.
Aye. All opposed? All right. We are unanimous. All right. Next.
Make
next
a
one.
motion to accept the minutes from June 30th, 2026.
Second.
All in favor?
Aye.
Aye.
Aye. And that's 3, and that's unanimous. All right. And the last one.
I make a motion to accept the minutes from July 14th, 2026 meeting.
Second.
All in favor?
Aye.
And I am an aye. All right. Next up, we have some relatively substantial changes to zoning law and the way that we are expected to conduct zoning variance and special permit reviews. And so to help us out with that, we have invited Ms. Carolyn Murray from KP Law to help us out and walk us through some of these changes and how they affect the way that we make decisions here. So with that, I'll let you get started.
Thank you, Mr. Chair, and since you've already introduced me, no need to do that, but nice to see some of you again, and nice to see some of you for the first time. And yes, the legislature was very busy over the beginning of July, and they're still busy considering some zoning amendments, so there may even be a part 2 to this training, we'll see. But as we go through this, I would just say there's sort of 2 common themes running through some of these changes that the legislature made. And one is a desire to remove some obstacles or perceived obstacles to development. And another, you will see that the legislature continues to emphasize and encourage housing and residential development. So you'll see how some of these changes would specifically impact that. And I know you also have on the agenda tonight a number of variances, and lucky you get to figure out and apply the new variance standard. So hopefully this will help with your later items on the agenda this evening.
You're not staying for those, though, are you?
I'm happy to stay if invited.
You do not need to stay.
Thank you. Thank you. So, Terry, if we could advance the slide, please. Thank you. So all of the changes that we're going to be talking about tonight were a creature of the budget bill. When the legislature passed it at the end of July, and it was signed by the governor on July 9th. It included a lot of what they call outside sections, which were specific amendments to Chapter 40A, the Zoning Act. And even though it was signed on July 9th, the effective date of these changes were retroactive to July 1st of 2026. So the 3 things that we're going to focus on tonight that were the primary changes are changes to notice requirements, changes with respect to Chapter 40A, Section 6, which is my all-time personal favorite statute relating to pre-existing non-conforming uses and structures and some of the zoning freeze protections that are already embedded in there. And then, last but not least, we'll talk about the changes to the variance standards. So if we could advance, thank you. So one thing I do just want to point out is with respect to notice changes, the notice requirements under Chapter 48 appear in 2 locations. One is in Section 5, which really won't impact the Zoning Board of Appeals because that is the section that deals with zoning amendments, and so the notices apply to Planning Board when they are holding public hearings with respect to proposed zoning changes. But then there is also Section 11, which applies to any sort of permit or zoning relief or petition under Chapter 40A. But you'll see the asterisk there that says it doesn't apply to variance applications. The legislature, in making the sausage, so to speak, they completely repealed Chapter 48, Section 10, the variance section, and replaced it with new language. And when they inserted the new language, they did not carry forward the same notice change that appears in Sections 5 and 11.
So in other words, if this change that we're about to discuss applies to any situation that's not a variance, so special
Correct.
permits, decisions, findings, but not for variance.
Correct.
Okay.
I completely anticipate that the variance statute will be amended again so that the notice provisions can be consistent throughout, but for the moment, that is
So-
just simply not the case.
So what is the notice requirement
So-
for variances?
So
No.
if Terry would just advance to the next slide, okay. So as it currently exists under Sections 5 and 11, and this is the same requirement that's in place up until June 30th of this year for variances, the notice requirements were that we had to post a notice at Town Hall in a conspicuous location 14 days prior. We had to publish in a newspaper twice in 2 consecutive weeks with the first advertisement appearing at least 14 days before whatever the date of the hearing was. And we had to mail notice to parties in interest, postage prepaid. The change to that, if we could go to the next slide. Thank you, Terry. The change now is to introduce electronic mailing. So you're still going to post at Town Hall. You're still required to publish in a newspaper. I know that's something that has been sort of an irritant amongst municipalities with more and more newspapers folding or publishing less frequently, so that it makes the ability to advertise those 14 days prior, 2 consecutive weeks, a little more challenging in some cases and perhaps a little more expensive. The legislature has not repealed that requirement, so we must still publish in the paper. But now you can mail notice to parties and abutters by regular mail, postage prepaid, or by electronic mail. But again, this doesn't apply to the variances.
So we don't have, as far as I know, a town-wide list of everybody's
Yes.
emails. So how does that work
Yes.
in practice?
So if we go to the next slide, Terry, you are absolutely correct. So the practicality of that is, how do we know people's email addresses? Or as we're taking, we usually get the abutters list from the assessors, and it's based on whoever was the record owner of that property as of a certain date. Well, we don't compile email addresses of property owners. We don't have any way of knowing, as people change their email addresses, we have no way of keeping up with those changes to email addresses. So while the legislature was trying to make this easier, I really don't know that there's going to be any practical change, to be honest. It's one thing if people voluntarily provide email addresses, but you're not going to have email addresses for, say, everyone that's a potential abutter. So I think you're still going to wind up mailing notices to abutters the good old-fashioned way.
And there's nothing about this that says that we can't continue to insist that it be mailed.
Correct.
Okay.
Correct.
All right, so in practice, this one's not quite ready for prime time.
Correct, yes. Did you have a further question?
I'm just wondering, in the sense of emailing, is that then allow for an abutter who, if the email goes to spam and they never actually got it, or, a junk man, the junk folder or something like that, or, one of the Google has, priorities and
Right.
so does
right.
that then allow for an abutter to essentially come back in later if, a meeting has taken place and decisions have been made and kind of go, I didn't get this?
Right. It's sort of the equivalent today of lots of communities require that the notices be mailed by certified mail because they want some sort of record that you did in fact mail it to these people or you've got that, green card. What we've certainly experienced over time, and perhaps it's the same here in North Andover, is people don't bother to pick up their certified mail. So if they aren't there when it's delivered, they're not going to bother to go and get it. So they never really know. But we, or the applicant, has met their obligation of, we sent you the notice. Whether you never ripped open the envelope or you didn't bother to read it or it got misplaced somewhere, we met our obligation of trying. And I think that's the purpose of mail alone is not a sufficient form of notice. That's why we post at town hall for people who happen to come through town hall, or why we also publish in a newspaper for those folks who still read the legal notices in newspapers. It's not a great system, admittedly, but I don't think anyone has been able to come up with a better solution. But to your point, if we say that notices can be sent by regular mail or email, and it winds up in a spam box somewhere, someone could say, I did not get the notice that I was entitled to. So the question will really become, did they still show up at your hearing and say, just for the record, I'm in a butter and I didn't get my notice, but you're here tonight. So clearly you found out about this hearing in some way. And the purpose of the notice was, come one, come all. If you are at least, if you are interested in hearing about this particular application, or if you want to comment on it, come to the meeting and present your comments to the board. So if a person shows up at a meeting and says, I didn't get my notice, there's no defect because you are here now, you've got constructive notice of that hearing. It could be a potential problem for folks if something is approved and they had no notice of it. And it's similar to if they didn't get that mailing now, would they challenge it or, appeal the decision of the board if they felt there was a defect in notice. That right still vests with them.
Okay. Thank you.
You're welcome.
All right.
So if we can move to the next slide. So there have also been some changes to, as I said, 48 Section 6 as it relates to nonconformity protections, abandonment timelines, and zoning freezes. So we'll go through each one of those. So first and foremost, as it exists right now, or as you've probably become accustomed to as the zoning board, that pre-existing nonconforming structures or uses can be altered subject to a finding, or in some cases, it might be subject to a special permit, that the proposed alteration is not substantially more detrimental to the neighborhood than what currently exists. That's what you've been accustomed to, or the current, or what was the standard up until June 30th. Now, if you have a pre-existing non-conforming structure or residential use that doesn't conform to zoning because of lot size or shape, frontage, lot coverage, or floor area ratios, and provided the alteration complies with height, setbacks, or the number of stories under your zoning bylaw, that structure can now, or the use, can now be altered as of right, meaning they no longer need a finding from this board that that proposed alteration is not substantially more detrimental. I know we had a little back and forth about this one, and we won't project about something that the board is going to be discussing later on tonight. But there was a situation with a potential alteration to a residential structure. But looking at it, the existing structure does not conform to dimensional setbacks. So any residential structure that currently doesn't conform to a residential setback, to a dimensional setback, is not entitled to this as-of-right extension.
I see. So if side, front, or rear setbacks are not part of this list, because.
Correct.
Okay.
And I think, I'm speculating, but I think the idea being that,
Sorry,
sure,
if the existing building does not conform to the setbacks, then it's not applicable, or if the addition doesn't comply with setbacks,
I
not
think it would be both.
Or either,
So
yeah.
right now, you'd have to be a pre-existing non-conforming structure or residential use that only doesn't conform because of lot size or shape, frontage, lot coverage, or floor area ratio. So if you are a structure that doesn't conform as to dimensional requirements, you don't meet that first prong of the test, so to speak.
So to
I
give an
think we have
example.
something in our bylaw, though, that I remember at a town meeting.
Right,
We,
so this
we
is
passed
what we
that.
were discussing relative to ADUs, right? So.
This was back from the 90s.
Oh, okay. So this overrides things in the town bylaw.
Yes.
Yeah, it sounds like it duplicates something we have in the bylaw.
Yeah, okay. Well, but to give an example, I guess, right? Let's say that if somebody has has a house with an attached garage, and they want to convert that garage to residential space, and the lot is smaller than the minimum lot size. Normally, that would require us to come in for a finding previously, but in this case, it would not. However, if that garage now is too close to the side of the lot and doesn't meet the setback requirements, that still comes to us for a finding.
Correct.
Okay.
Correct.
Does that distinction make sense?
Even if it's pre-existing, non-conforming?
Yes. Yes. So I think the rationale, if I can get into the minds of the legislature, which is a little dangerous, but I think the rationale is and you see this far more than I do, to the chair's example, people want to put, have an undersized lot, but they have a house on it, and they have a garage or whatever, and they just want to put an extension onto their house, and the extension completely conforms with zoning,
Except for those.
except for, say, lot size in that example. Yet they now have to come before the Zoning Board of Appeals, and my guess would be that folks have to go through filing the application and providing notice to abutters and getting that certified abutters list and showing up at a hearing for the Zoning Board of Appeals to essentially spend about 5 minutes saying, so it conforms with zoning in every way except as to lot size. Yes, here you go, your finding is granted, and, it just takes longer for people to develop their property. But I think the legislature is still sending a message that they recognize if the nonconformity is as to setbacks, that's a different matter altogether, because setbacks now start to encroach upon the property next door. So if it's a structure that's nonconforming as to setbacks, that is still going to have to come before this board for a finding to alter it.
All right.
All right?
So that decision's really made, though, by the building commissioner to decide whether it's coming to us or not when they go in for a permit.
It probably is, yes. Yes, in the first instance, yes. So glad you're here.
So the notices piece is on Terry, and you got this piece.
All right.
Complicated every day.
So the one concern, or the one thing I do want to flag here, though, is that the statute refers to pre-existing non-conforming structures or residential uses. And residential uses is new. And it begs the question of exactly, well, we know what we're talking about with respect to a pre-existing non-conforming structure. What are we talking about when we just say residential uses? I don't think it's the house, because I think that would be a pre-existing non-conforming structure. But perhaps it is a garage, a shed, an in-law apartment. Perhaps it's an ADU.
Well, I was going to ask if it's
Well, those
a
things are
situation
structures.
where if it was a pre-existing duplex, but then the area was zoned for single family, then it's saying that then you can retain its ability to be a duplex. Maybe that's...
But that's what the law is now.
Okay, it already exists that way. Yeah.
Or if it's not in a residential zone, if it was a house built.
But still,
in a
if
commercial zone.
something was lawfully existing, and then a zoning change came and was adopted and rendered that structure or that use non-conforming, like a residential use, and now we've zoned it commercial and we've said residential uses aren't allowed in the commercial zone, that residential use is still allowed to exist in the commercial zone. That residential use is allowed to expand or be altered, subject to a finding of this board. At least that's the way it used to be.
Right,
So
so I'm
now
wondering
they
if
don't-
this is
now they
that,
don't need
maybe
the
they don't
finding.
need a finding now.
It's a little unclear what
Yeah.
was meant.
Okay.
I'm gonna go with the left hand, didn't know what the right hand was doing.
I'll
say it.
Wait till we get to variances.
There is an exception to that. Single families can go through, in our bylaw, a series of alterations without receiving a finding. There's 5 sections on that. A little bit
right.
different than a lot of other communities.
Right. And you'll see at the end here, I did just note a few provisions of the zoning bylaw that I would recommend the town take a closer look at, just to see, do we now need to amend the bylaw so that it's consistent with state law? Because we're not allowed to have a bylaw that's inconsistent with state law, so.
Who, that's really the planning board.
That's the
So
Yes,
that's,
yep.
that's being addressed with them, someone
Well,
is.
I did forward this presentation to the planning board and let them know that it is happening today, so.
Right.
So if we could go to the next one, Terry, please. So abandonment, and this might again be something that falls more to your building inspector, but abandonment, as you may recall, that non-conforming uses or structures could be deemed abandoned if they were not used or were discontinued for a period of 2 years or more. That has now been extended to 4 years to prove discontinuance or abandonment. I think that one is pretty straightforward, and if we could move to the next one, please, Terry. So expansion of protection from subsequent zoning changes. So as we were just talking about a moment ago, if you had, say, a residential use that was lawfully existing, you changed your bylaw, and now it's in a commercial zone, and residential uses are no longer allowed, that use would be allowed to continue, but obviously it would be pre-existing non-conforming. Chapter 48, Section 6 also made a provision that if a zoning change was adopted, it would not apply to a project that either received a building permit or received a special permit before the first notice of the planning board's publication of a proposed zoning amendment hit the newspapers. That was always sort of a difficult provision, I think, in 48 for a lot of folks to understand, because the question we would get would be, well, but, so you're telling me that a zoning change is going to apply to an application that comes in after the first legal ad hits the paper?
Yeah.
But that first legal ad could appear sometime in March, and you don't have town meeting until May, and what happens if town meeting doesn't approve that zoning change? Well, you know, we said, well, that was always a limbo period where you'd have to apply the new bylaw as if it had been adopted, but recognize that if it isn't adopted, the applicant is really proceeding at risk. So that has been changed. And I think this is one of those areas where it does eliminate some confusion, but so now a permit applicant is protected from subsequent zoning changes even if they have simply applied for a permit or other entitlement. So previously, they had to have a building permit or special permit issued. Now they just have to apply for that building permit or special permit, and any zoning changes that might be contemplated, in the background or by the planning board during the spring town meeting season or whatever, is not going to impact that application. But the statute also now introduces this word, other entitlement. They didn't bother to define, and it's located no place else in Chapter 40A. So if we could advance that slide, please, Terry. So it's not clear what that means. I mean, we certainly understand what it means to have applied for a building permit, special permit, or whatever. Other entitlements tends to suggest that it is something to which you have a right to, meaning not perhaps a discretionary permit like a special permit has traditionally been interpreted as. It's possible that the legislature is referring to site plan approval here. It's possible that they're talking about other permits outside of Chapter 40A. Really, this is going to be one of those instances that I think is going to take a court or the legislature to clarify before we really know what this means to apply for an other entitlement. Go to the next one, please, Terry. So the changes.
Excuse me, so.
Sure.
So they're sort of locked in once they get their application into the current zoning, but you're saying changes to, say, a site plan approval process might still apply to them?
So currently, if you have received a building permit or special permit before the first day that any proposed zoning amendment is advertised,
Right.
that zoning change does not apply to you. You've got your building permit, you've got your special
Right.
permit. But
So
that
that-
zoning amendment would apply to any future changes. And it would apply if you didn't, we're going to get to that at this slide momentarily, it would apply if you didn't actually start construction within what used to be 12 months of obtaining those permits. Now, it's saying that all you have to do is apply for a permit. You don't even have to get the permit. You simply have to apply for a permit, and any zoning changes that are being contemplated.
Right, but I mean, the entitlement piece of it, what's the question there?
The question is, what is an entitlement?
I know, but what would be the, say we knew that a site plan approval was an entitlement, then if they make changes to the regulations about site plan approval, that would affect you, or wouldn't-
But
or
they
you-
submitted their application for site plan approval, yes, that could be one possible outcome.
that it would affect you, or wouldn't, the change to the site plan approval would
As
affect you,
long-
or wouldn't?
As long as you apply,
Then it wouldn't affect you.
it
Okay.
would not affect you.
So changes to water and sewer regulations, if that's an entitlement.
If that's an
whatever-
entitlement,
whatever-
right,
Yeah,
exactly.
then those would not affect you, I got you.
Exactly.
So okay.
Yes. Now, so the second part of this then becomes, you get that so-called, zoning freeze, meaning you've applied for whatever your zoning permits happen to be, but it used to be that zoning changes would not apply to you if you commenced construction within 12 months of the date that the permit was issued. That's been extended to 24 months and is further extended to being 24 months from the issuance of the last permit necessary for the construction. So if you have a project now that might require a variance, an order of conditions, site plan approval, maybe even a special permit, now, while all of those things are being actively pursued,
Your clock hasn't started.
the clock doesn't start to tick until the last one is actually issued, and then you get 24 months from then to start construction. So merger. you know that the zoning board often has occasion to deal with the question of merger. But the concept comes from this idea in zoning that if you have undersized lots that are held in common, that are adjacent to each other, and they're held in common ownership, they are typically deemed to merge for purposes of zoning, and that's kind of a term of art under 40A. The idea is that zoning wants to eliminate nonconformities or make lots more conforming. So if you happen to own a series of undersized lots that are contiguous to each other and they're all held in common ownership, they in theory could merge for purposes of zoning, unless of course there was an exception that was made to protect certain lots that were held for single and two-family residential uses, provided those lots had at least 50 feet of frontage and 5,000 square feet if they were held in common ownership. If they were not held in common ownership, if they were not held in common ownership and had 50 feet of frontage and 5,000 square feet of area, and it was a lot for single or two-family use, they could argue that they were protected under the Zoning Act as still being a buildable lot. If you did have lots that were contiguous to each other, that were undersized, and that were held in common ownership, as long as you had 75 feet of frontage and 7,500 square feet of lot area, that could still be considered a buildable lot for a period of 5 years from the date that a zoning amendment was adopted to render them not buildable. The legislature has struck from this sentence a lot for single and two-family residential use. So now any lot that meets these area and frontage requirements is technically protected from merger and could be deemed a buildable lot.
Yeah, that has come up in the auspice of a variance before from our board. So
Okay.
like in a reverse way, we've had to deal with this before.
Okay. So next, let's talk about variances. And as I mentioned, the legislature completely repealed Chapter 48, Section 10, the variance statute, and completely rewrote it. And if we could advance to the next one, thank you. So the previous standard, and this is pretty consistent with Section 10.8 of your zoning bylaw, that essentially that due to some sort of circumstance related to shape, soil, or topography of the lot, that literal enforcement of your zoning bylaw presented some sort of a hardship that was unique to that lot and not generally affecting the zoning district, an applicant could seek a variance, essentially a dimensional variance, based on shape, soil, or topography. That has been replaced with a new standard of whether or not strict enforcement of the ordinance or the bylaw would result in practical difficulty. And if we can go to the next page, please. So what is practical difficulty? So in making your determination, you are supposed to weigh the benefits of the appellant or the petitioner to the public and to the public interest, including the interest in creating housing, against the detriment to the public health, safety, and welfare of the neighborhood. And you may still consider shape, soil, or topography. You may still consider whether or not strict enforcement would impose a financial hardship on the petitioner. You may consider whether the benefit sought by the appellant or the petitioner can be achieved by some other means. And you can consider whether or not the practical difficulty was self-created.
So, previously we've had discussions about hardship, right, where we need to define a hardship for a variance that has been created and have that as the starting point for whether or not then we can commence with the rest of the discussion. And it sounds like this is not altogether eliminating that, but broadening it substantially.
Exactly. exactly.
But just about housing.
Not exclusively about housing, but now you can consider that in making your decision.
So it applies to a variance for signage.
If it was applicable, yes, it would. So if your zoning bylaw only allowed, a 20 square foot sign in a particular district, and someone came in and applied for a 25 square foot sign, yes, you're now applying this standard to variances. So you're no longer just looking at shape, soil, and topography. I
So
will
it's
say,
just if it's determined that it's in the public interest.
essentially,
And not detrimental to.
And whether it's necessary, right? Because it's whether or not, we're allowed to consider whether or not it's achievable by some other means.
right.
And also whether they did it to themselves. In other words, like, if they
But we don't have to.
committed some kind of change, right, but we're allowed to consider those
Right,
things,
Mm-hmm.
right?
yeah,
Right.
But yes, we do not have to limit ourselves by those, but
Right.
we can consider them.
So this is probably going to be the biggest adjustment for this board going forward. And there isn't any case law at this point to help us really say, what is a
Yeah.
practical difficulty? Or I've already gotten questions from folks saying, what wouldn't be self-created? The applicant is the one that controls the design of the lot or the structures on the lot. How would it not be self-created? Well, maybe we'll know it when we see it.
Does the
Or,
language come from other jurisdictions? I mean, is it, did they, from whole cloth make up this language, or is there case law from other jurisdictions that might be persuasive, or?
I haven't seen anything in the legislative history that refers to other jurisdictions and this standard. I wouldn't be surprised if maybe it was borrowed from some other locations, and maybe that influenced the legislatures or the legislators who introduced this specific language. But it is still, it would have been helpful, define practical difficulty for us.
Yeah.
Define entitlement, so that rather than just using this language.
Yeah. I mean, it seems pretty clearly an effort to lower the standard.
Yes.
So exactly where, I guess we'll find out.
Yes, we will. And if we can turn to the next page, we'll even, so we've talked about, what is a practical difficulty, and that really remains to be seen. But if we could go to the next slide, please, Terry. Here's the other sea change for you. Use variances. So it used to be that the statute required that a bylaw or ordinance had to expressly authorize use variances. And if it wasn't in your bylaw, you weren't allowed to issue them. Now that's been changed to this new sentence that says, except where local ordinance or bylaws expressly permit variances for use. So, okay, those of you out there who already allow use variances are sort of put to the side. No variance may authorize a use or activity other than residential, not otherwise permitted in the district in which the land or structure is located. So now, despite whatever your bylaw may say about use variances, you're now allowed by state law to grant a use variance for residential uses only.
So in other words, for example, let's say that there's a commercial section, right? And it's been zoned for commercial only, and they want to make it mixed use, right? Then under those circumstances, they would be allowed to ask for a special permit to make that residential as well as commercial.
Or in this case now, a use variance for the residential component of it.
Right.
Yes.
Okay.
Yes, so that's probably going to be one of the biggest changes that the board's going to face. Another thing that was changed in the statute is there was language in there that allowed a zoning board to condition or impose conditions and safeguards in a variance. That language was completely struck in the rewrite. So there has been an awful lot of discussion, and if any of you are on any of like the planning and zoning listservs, perhaps you've seen some of this chatter. There are those who are of the opinion that variances can no longer be conditioned. That's it, because when the legislature amends legislation, they're fully aware of language that exists that they are striking. They're fully aware of other statutes, and that the omission of that language is deemed to be deliberate and intentional on the part of the legislature. There are also some others who are of the opinion that implied in the ability to issue a variance is the power to also condition that variance. Unfortunately, until someone actually tries to condition a variance and an applicant challenges that, we're not going to know who wins that battle.
Well, and practically speaking, I mean, obviously, we're not here to judge how the state legislature run things, but I do worry that that would mean that we're less likely to permit a variance, because then we can't add conditions that might make it more palatable to us.
That's a fair point.
Well, can't we say, instead of it being a condition to our decision, have them put that on their plans? The items that we want to be included, so that when we approve the plan and reference that into the decision, then that condition is included, but not as a condition, but part of the plan.
You could, and in the practice tip that we threw on the slide is, one thought is work this into your findings somehow. And I think that it could also go along hand in hand with adding a notation on the plan. All of that, of course, presupposes that the applicant is willing to agree to that condition.
Yes, and also.
Well, as it always
Also
was.
us being,
Right.
but it's also conditioned on us being willing to approve the variance.
Yes, but you could be in a situation where the applicant says, no, I'm not willing to put that notation on the plan for whatever reason. Well,
Then we choose whether we're willing to vote for it.
then you choose whether you're willing to grant the variance or not. That's one possibility. Or do you work it into your decision somehow? And I'll give you an example. I was at another zoning board meeting on July 12th, literally 3 days after this had been handed down by the legislature. And they had a variance on their agenda. And the variance was seeking to create an undersized lot, because they were going to go to the planning board for a subdivision. But one of the lots that they wanted to create was not going to have the required frontage and lot area. So they needed the variance from the Zoning Board of Appeals. The Zoning Board of Appeals heard what I had to say about the new variance standard, but then they said, but the whole purpose of this variance is only to create this lot, provided they actually go forward with that subdivision. Because otherwise, if we just grant this variance and they don't go forward with the subdivision, there's the potential for them to effectively have two principal uses on one lot, which is not the variance that was sought and not the variance they were granting. So I will find out if I'm right or I'm wrong. I said, go ahead and condition that variance, subject to this being, conditioned upon the applicant's representation that the sole purpose is to create this lot for a subdivision, and that they must actually seek that subdivision. The applicant in that case was not contesting the issue,
Right.
because that was their intent. But, we're still, there's still the possibility that someone else could come along and say, well, I'm not quite so willing to agree to that condition, in which case you either deny it or they appeal the condition. And we find out what the court feels about this change to the legislation.
Okay, so we are a little bit in the Wild West
A
here.
little bit in the Wild West. So one further change, if we could go forward, Terry, please. Thanks. So one other change you have been accustomed to is that a variance has been good for 1 year, and that you had the ability to extend that variance for 6 months. That's now been extended to 2 years. And it includes, as we were talking about earlier, in another context, it includes the time necessary to pursue other entitlements to construct the project.
So like other boards, other things it would need from the board, presumably, from boards in town, presumably.
I would think, but again,
Right, yeah, it excludes the time, as in it takes place after it gets final approval,
yes,
basically.
yes. And it excludes the time to wait for the determination of an appeal. So if a variance is granted and an abutter appeals it, that time doesn't eat into your full 2 years. It'll be after the appeal is over. I think in this context, I think the other entitlement is likely the building permit, because if you were granted the variance, then you then do have a right to a building permit pursuant to that variance, but it's not clear what else the legislature meant by that language.
And it doesn't matter how long it takes them to get the building permit?
Just the time necessary to pursue them.
Because typically in larger projects, they won't even start the construction documents till this is done, and that those can take
Right.
a year.
And
If you're on a
again,
big project.
I think the motivation behind these changes is to make it easier for development, so that they don't have a variance expire on them and then have to reapply for a new variance.
Okay.
All right.
So then, just as a preview for some other things, the Economic Development Bill, that is still in conference committee between the House and the Senate. Some things that might be coming down the pipeline are, they're considering duplexes in all zoning districts and ADUs in all zoning districts. Site plan review would be something that would be regulated now by statute and uniform. Permanent optional hybrid meetings,
I like that.
which a number
We'll
of...
never see you again.
I was going to say, a number of communities have been doing that anyway, but it would finally make that permanent as opposed to just operating under the, yes, we're still under COVID extensions. Training for special permit granting authorities is something that has been considered. A further permit extension act, and also commercial conversion to residential uses is something that the legislature is considering. One thing that was removed from the Senate bill, if anyone was following this, was sometimes what was referred to as YIGBY, or Yes to God in My Backyard. That would have allowed surplus, like religious properties, to be redeveloped for housing, and in particular affordable housing. That did not make it through the Senate's version of the bill, so I'm not suggesting we won't see that be reintroduced at a further date, but it's not currently part of their consideration.
And there's also, I believe, a ballot measure that
Yes,
would
yes.
change the minimum lot size.
Yes, correct. So we'll see what happens in the coming months.
Quick question, just
Sure.
out of curiosity. If I recall correctly, ADUs are currently just on single family. So is that essentially going to change it so that an ADU can be placed on a commercial property, a three-family? Is that, okay.
Well-
The smile answer.
Well, I still think, right now ADUs are only allowed in districts where single-family houses are allowed, right? So I think what this is saying is that if you had a single-family house, like in a commercial district, that it could still have an ADU. I also think that it doesn't mean that businesses can just add ADUs, because remember, it's supposed to be an accessory dwelling unit, so meaning what? It's accessory to, at least under the current statute, it's accessory to a principal dwelling. It's not accessory to a commercial use. But we'll see what the final version looks like. We did raise this issue because we've been allowed to see some pieces of the legislation, and the Mass Municipal Association will, it's almost like that first 2 weeks of July was every other time you looked in your inbox, there's another email saying, how do you feel about duplexes in all zoning districts? You know, you have 30 minutes to reply. And we weighed in on things saying, well, the way you've defined a duplex, it would include a single-family house with an accessory dwelling unit. And now you're saying that on top of that, an accessory dwelling unit is allowed, so aren't we basically saying that triplexes or triplexes are allowed everywhere?
I was gonna say, so then that would put like a single-family home with an ADU with a two-family?
Potentially. Like I said, we will wait to see what the final language is, or to even see if it makes the final cut. But these are the things on the horizon.
I'll be retiring.
All right.
And then last but not least, this, we don't have to spend any time on it, but the slide identifying just some portions of your zoning bylaws that might need to be looked at. Since you've shared that with the planning board, I think they will have a busy season ahead of them, so.
All right, thank you. Any other questions before I let Ms. Murray go?
She's not gonna stay for the rest?
Not unless she really wants to. All right.
No offense, I enjoy my time with you all, but.
Thank you. Thank you so much.
And, good luck
Thank you.
with all of this, really. Have a good night.
All right, take care. All right, moving on to 64 Old Cart Way. Mr. Vanderval, I want to understand a little bit here. We've not dealt with a modification of decision like this in quite some time. Usually when we introduce a new topic, we have our public meeting notice that we read in. I don't think we have one of those for this. Is that correct?
We didn't go through the same advertising process because it's a modification to an
Right.
existing variant, so
Right.
it's a little different.
And so I guess the question is what is the proper way for us to introduce this? Do we just say we're just going to start with this and?
I think what you've got there in your agenda is enough to start the conversation.
Okay.
And then we get into this minor, major, and whether it needs to go for further review, or if it's insignificant enough, you can go ahead and
Okay.
approve it.
All right. So, Mr. Clerk, do you want to give it a shot?
I'll just read this,
Yeah,
this
that
section right here.
works.
I'll say review or,
We're reviewing the petition of,
Okay.
yeah.
reviewing a petition for a modification of decision at 64 Old Cart Way. Do you want to help me? Just
By Sukesh Shigara.
Sukashigara? Okay. The petition of Sukashigara for property at 64 Old Cart Way, map 107.B, parcel 87, North Andover, Massachusetts, 01845 in the R2 zoning district. The applicant is requesting a variance pursuant to Town of North Andover zoning bylaws, section 195-7.3, yards, setbacks, table 2, summary of dimensional requirements for one side setback in the R2 zoning district for the purpose of constructing an addition onto the existing home. Specifically, applicant has requested the right side setback needing a relief variance of 15.4 feet. Side setback proposed is 14.6 feet. Side setback required per table 2 is 30 feet.
All right, Mr. Gara, please come on up.
Can I just ask a quick question of Terry?
Yes.
Signed copy. Terry, is there a signed copy of the modification? Because the copy I have isn't signed. Well, this is the application.
Yeah.
So wouldn't the application be signed? Am I misunderstanding?
No, I think you're right. Right, but it could
Okay.
be signed before the meeting.
Okay.
Yeah, because I think this is, yeah, I think when they apply, they should sign it. Just make it official. What is the best way to proceed here? Because I know there's a bit of explanation that's going to come forth. Does it make sense to come from Mr. Agara? Should it come from
I
you?
think it should come from Mr. Agara.
Okay.
To explain why it may be a minor change that doesn't require
Okay.
renotice versus your determination it might be such a major change that you
Okay.
need to renotice. That really comes from his description of what he's trying to do.
Okay. All right. So, welcome. And please state your names and your address for the record, and then we'll get started.
Sukesh Agara, 64 Old Cart Way.
I'm Rachel Agara at 64 Old Cartway.
All right, welcome.
Well, thank you. That was a heavy review of variance and zoning board, so
Yeah, I bet you didn't know you were signing up for that, right?
yeah, I appreciate everything that you guys
There are
do.
no credits for listening to that.
Hey, this is why I know I ended up being an engineer and not a lawyer. But basically, we had originally requested the setback because of the very unique corner that is at the entry point of our house.
Yep.
And the zoning board had granted the setback. We are making a modification that is further away from where the approval is. So we're not changing the request for the setback that you have. So we're still staying the same place.
Okay.
So we're not encroaching any further than what the approved amount was.
So what is the change then?
So the change that we are doing is between when you guys approved it 2 years ago and now, we lost my father-in-law, and in the process we learned how wheelchairs work and how 2 levels don't work, and so basically that was, and we lost a contractor as well along the process, but so anyway, we are now basically making it in same level. Originally we had 2 levels, so it's actually single level so that wheelchairs can move. And we also realized that the narrowness between the stairs and the exterior wall would be more difficult. So all we are doing is adding 4 feet on the, not the variance side, but then the further down.
Got it.
Yes.
So sorry, we're just trying to make sure we have the plans sorted out correctly. So there are 2 plot plans.
The same date on it.
The same date?
Oh,
Same days.
one lists the 20.
Yes, so
from
one
20.
has the addition on it, right? So
Yeah, it just has the difference in the,
yes, we just need to be able we just need to make sure that we cite the correct one. Okay, so, but that is, right, so it's adding 4 feet out. There's a corner that is closest to that troublesome corner.
yeah.
So not this one, Terry, but further down in the, yeah, this one. So there's a corner here that is closest, but this is still further than the closest part here.
Correct.
That's the idea?
Yeah, so the
It's a little
14,
bit-
What's the difference between these two? I still don't see the difference.
The little red box.
We're gonna add that 4-foot section to this.
Yeah, it's this one versus this one.
Oh, I can see that one.
There's more.
I see these two.
yeah. So basically no change to the 14.6 setback that was approved.
Okay.
Oh, yeah, I got it.
It
Okay.
doesn't implicate any other setbacks or
No.
rear yard requirements. There's no other nonconformities that it creates. Or,
I mean, you can see it, the lot is very uniquely weird, and has a lot of additional space. It's just that corner, and that's the frontest part of the house, closest to the driveway.
So is the question that we already granted the 14.6, and now we would have to grant the new 20-foot?
Well, that's not a new 20-foot. What it is that we'd be saying that replacing the old plan with this new plan is an insubstantial change that does not require a fresh variance. Because otherwise, we would be requiring that the applicant file a public notice, come back with a whole new variance, and that we come in and debate and discuss that new variance.
I don't think anyone even voted no on it. last time.
No, it was unanimous.
I think you're effectively changing the shape without encroaching.
Yeah. So, I mean, look, whether or not it's a substantial, I believe in my true heart of hearts that it's a substantial change. I do not think it's worth bringing you back and making you go through the whole process here. That's my own leanings towards it. But anyone else have any thoughts or questions before we have a real discussion?
Fine with it also, unless there's any abutters who have a comment or.
Yeah. Is there anyone from the public that is here to discuss this? I am guessing that they are not. Okay. So I believe, Mr. Vanderwall, that we need 3 out of 5 votes, right? That is the standard for this item?
I don't know that you've ever specifically defined it. I'm going to go with what it is a modification to a variance.
Okay, so
So I'm going to go with the supermajority
Okay.
because that is what's the only language that's applicable to use in this.
Okay, all right.
So,
I think for the sake of this particular item, that's okay. I think I may want to figure out long-term whether that's what we want to do or not.
and that's something, if you decide you want to go a different route, you put into your rules and regulations, and that sets the new standard for it.
All right. Any other thoughts? All right.
Well,
Go ahead.
Yeah, these plans aren't really distinguished, so if I was going to reference the plan in the, in the reading here,
Yeah.
I want it to be,
I think we can say the plan with the new included design with a 20-foot distance from the corner. I mean, I guess that's the best we can do, right? Because we don't have a distinguishing mark on the plan.
Chairman? I have seen cases where boards have marked up it and submitted it back to the secretary as the record.
Okay, so we just
So if
choose,
you-
we just hand her the form.
Yes. That
Okay.
becomes the record that enters into her decisioning.
That can work. So Terry, the sheet that Mr. Killalay will hand you is a golden sheet. It is the it is the magic one that is the correct one.
Chair is, we have 2 alternates, are they gonna alternate voting, and who's gonna be voting on it?
So right, so I think we'll start this one with Mr. Ginsburg, and then the next item we'll move to Mr. Hatchie, and then we'll go back and forth on
Okay,
this.
let's make sure we're clear
Yep.
on who's
Yep.
who.
I think that works. All right.
Oh.
Do we have a motion to?
So, can I just ask one question?
Yeah,
Right.
yeah.
So,
so we're,
wait a minute, Frank. This was originally approved 2 years ago?
Yes.
So,
3 years ago,
Shouldn't it be?
2023. I think it was 2023. It was included in
No,
the
well, the plan says
documentation was included
2024.
in here. Maybe it's 2024. Maybe I'm wrong. Anyways, go on.
So does the 2 years restart from today? Does he get another 2 years to start?
Well, I think under those wonderful new revisions, I think it would be 2 years.
I think the question of yours is a fair one.
Because
Mr.
this
Vanderwall,
was-
does he need to also ask for an extension?
Because this was applied for before that, I'm
Yeah,
assuming,
yeah.
right?
And there's an intervening law that gave him extended tolling time, so you go through all the math, and he did not have to apply for an extension, which is what we initially thought. Does the modification apply to the extension, or the 2 years?
Does it give him a fresh clock?
That's my question. Does he
Yeah.
get a-
As a question I've never been confronted, but since it's only a modification to the originally issued variance, I don't think so.
Okay.
You're modifying it, you're not reconstituting the variance, therefore triggering a whole new time clock. So he has submitted building permit paperwork, so we're
Okay.
certainly ready to get going. I don't think it'll be a significant
Okay.
issue.
So you don't think we need to ask that he needs to be asking for an extension because we can.
I think we determined that wasn't necessary because of the
Okay.
tolling of some other various laws that kick in, so.
Okay.
so you plan to
Just
start?
want to make sure you're good before you leave.
We don't want to
Thank
get you
you.
in trouble.
I don't want you to come back.
All right. Do we have a motion to close the public comment?
I'll make a motion to close the public comment.
Second. All in favor?
Aye.
Aye. All right. Any deliberations?
How many conditions can we put on this?
Unclear.
Yeah, that is the correct answer. All right.
Make them the guinea pigs.
Yeah. All right.
Let's vote.
Yeah. Are you ready to? Do you have?
Well,
some
so,
phrasing?
so what we're trying to, well, what we have to decide is it minor or not? So, so the way, the motion would be to find, make a motion to find that it is a minor modification.
Right. Yes.
Right.
Always in the affirmative.
Yeah. And then we would say, reference the site plan by, what was it by? Spindle City, dated 9/19, what? As,
That as given by the clerk to.
Or as notated
Yeah.
today, or whatever you
Yeah.
put on it.
notated. I don't know how you spell notated.
We won't hold it against you.
That would be a fun court case.
We want to add, like,
Notated by the board,
Yeah.
or so by the chair,
Sure.
on 8/18/26, and issued to the proponent. I'll try that.
All right.
All right.
Let's try it out.
All right. I make a motion to find that a minor modification to the
That the requested
decision,
modification.
that the requested modification for 64 Old Cart Way is a minor modification from the petition of Sukesh Agara for property at 64 Old Cart Way, map 107.B, parcel 87, North Andover, Mass. 01845, in the R2 zoning district. The applicant is requesting, I don't want to say that.
No, you don't need to say that part.
Yeah.
As presented.
Yep. As presented on the site plan, as notated by the chair on 8/18/26, and issued to the proponent. That's a little awkward, but.
It'll work. Do we have a second?
I'll second.
All right. Mr. Ginsburg.
Aye.
Mr. Testa.
Aye.
Ms. Jacobs.
Aye.
Mr. Killalay.
Aye.
And I am an aye. All right. Congratulations.
Thank you very much.
Have a good night.
Yeah.
I'm glad I brought my boys with me so they know one of them's thinking about law.
Yeah.
So
Can
should
I
we,
talk you out of it anytime
should we give him a
soon?
site plan?
Recommend against.
Should we
Yes.
notate it?
Yes.
And, we'll give it to Terry? So she
Yeah, I'll
can-
give it to Terry. All right.
Mr. Chairman?
Yes.
And I do want to reach back to my time on a zoning board in another community. It was not uncommon to say, I don't like what your variance is, we're going to come up with a different dimension, write it right on the drawing, stamp it, and that was the new. So you can
Yes.
do that within the meeting if that comes up to a decision.
Okay. All righty. Our next item. Where we go? We have 79 Chickering Road.
He's out of order.
Please come on up. And Mr. Killalay will read us in.
Okay. Notice is hereby given that the North Andover Zoning Board of Appeals will hold a public hearing at the North Andover Town Hall at 120 Main Street, North Andover, Massachusetts, on Tuesday, August 18th, 2026, at 7:30 PM, to all parties interested in the petition of Joseph H. Buckholz Jr. for property at 79 Chickering Road, map 46, parcel 22, North Andover, Massachusetts, 01845, in the GB zoning district. The applicant is requesting a variance pursuant to Town of North Andover zoning bylaws, section 195-6.5.A, Table 2, dimensional requirements, for the purposes of constructing an internally lit ground sign with LED gas price modules. Application and supporting materials are available for review at the office of the zoning department located at 120 Main Street, North Andover, Massachusetts, on Monday and Tuesday from the hours of 8:30 a.m. to 3 p.m. and Thursday from the hours of 8:30 a.m. to 4 p.m. By order of the Board of Appeals, Michael T. List, Chair.
All right, welcome. Please identify yourself for the record.
My name is Joseph Buckles Jr. from Buckles Signs since 1899. I'm representing Super Petroleum, that runs the gas station. I'd like to clarify something, and I'm going to ask a question, because we were told we cannot do internally illuminated, and I thought I wrote internally, externally illuminated on the application. Does the town allow, by variance, internally illuminated signs? Because we'd much rather do that.
Well, you can apply for a variance. We may not grant that.
Well, if it's listed as that's what I'm asking for,
Well, so the LED,
the LED is
the
one
lettering,
component.
the LED lettering, it counts as internally illuminated.
Okay, so,
So,
all right. So my drawing lists this as an externally lit on the top, the floodlight, the Super Petroleum,
Yeah.
and just the numbers are the LED.
Yes.
That's what we're asking for.
yes,
Okay.
yes,
Because
that
I'd
is
love
my
to have it
understanding.
internally lit, but I don't think you allow them in town.
I'll say this, look at other gas stations in North Andover and see if you can find anywhere the entire sign
I
is
did,
interior.
that's why, when it sent it on the list, I
Yeah.
wanted to clarify, because I don't want to misrepresent.
So,
what I'm
to
proposing.
clarify,
That
you
mobile
you
station
can
is, isn't it?
ask, you can ask for the
Look at
whole
that.
sign to be internally lit as a variance. We may or may not grant that, and that's a whole nother discussion.
Right.
And so, yes, my understanding is of what you were asking for here was an externally illuminated sign except for the price lettering,
Correct.
which is
Okay.
then internally illuminated.
Just wanted to be clear, I didn't want any misrepresentation.
Yeah.
So, again, we're proposing to replace the existing sign, it's the same size sign, and all we're asking is the permission to use LED price modules as opposed to manual change items. Those manual change items are obsolete, people can get hurt, they can fall out and hit people, and it's the common practice now is to be able to change these through their POS system, which is a system that changes the gas price, so all the prices stay consistent on the property at the same time. A lot of times the manuals, somebody will forget to change it, or they'll lose a number, and the price is wrong, and the customers complain. So this is the new, it's pretty much standard for gas signs. We're asking permission to be able to do it. I believe there are other stations in town that do have these, so I think it's an unfair advantage if we can't, but that's our proposal.
Any questions?
My only question, because I'm making sure bazillion times, exterior illuminated for the part that says Super Petroleum, and then the pricing only is going to be the interior LED.
Correct.
Okay.
The top of the sign, there's gonna be an LED formed piece with LED lighting that comes down and hits the sign. No floodlights running around, it just comes down on the sign and that's it.
Perfect.
That's a fair question. Because I said it was posted wrong, I'm like, wait a minute.
Look around North Andover.
I know, that's what I said. It's allowed, I'd love to have it, but I didn't think we could, and I believe I talked to the building inspector, he said no, so.
It's a sticking point here.
One, right?
I just don't know how it
Yeah.
got changed, I really don't.
Yeah.
By Market Basket.
Yeah.
They're not, I don't believe
It's-
inside is interior.
I believe it is because it was
They
pre-existing
already had
already.
one.
Oh.
They put a new one up.
the one I messed up.
Yeah.
Yeah.
No.
Oh,
No.
there was one down by Market Basket.
114.
It's right on the
It's
Lawrence
competing
line.
with like 5 other.
Right across the
Anyway.
street from that super cheap.
Anyway,
Back to you.
all right. Mr. Hatchie, Mr. Ginsburg, any questions? All right, is anyone here from the public to discuss this particular? Please identify your name and address for the record.
My name is Roger Lawson. I live at 16 Dufton Court.
Hi.
I'm just wondering what the height of the new LED numbers would be.
I believe they're 16-inch digits.
Okay, and what are the existing vinyl?
18,
Oh, okay, great,
smaller than existing.
great. Okay, thank you.
All right. For the future, for all folks, please address the board rather than the applicant. Just it keeps things a little bit more civil when it gets testy. But thank you very much. All right. Any additional thoughts? Do we have a motion to close the public comment? Oh, sorry.
I can't read the date on that plan. Can you? I'm going to reference it.
July 14th, 2025.
Okay.
Thank you.
And
I've got a few more years before my vision does not
My
let me do that
keepers are
anymore.
going.
is the plan by, is the,
Instead
pla-
of changing, I'm like, whoa.
right, is the plan by GPI?
That was submitted to me by the landlord. I don't know
Okay.
who created it. They go certified.
Engineering,
Design
design, yeah,
plan.
so it's probably a plan by. What to say? Okay.
All right. Do we have a motion to close the public comment?
I'll make a motion to close the public comment.
I'll second.
All right. All in favor?
Aye.
And I'm an aye. All right, we are deliberating.
No discussion.
Do we need a
No,
discussion?
no, I'm good. I just,
Do you want to be here later?
I'm good. My paperwork's already turned over and down.
All right. Any discussion before we start voting? Okay. I think we can just read it in.
Okay, and make a motion to approve a variance pursuant to Town of North Andover zoning bylaws, section 195-6.5A, table 2, dimensional requirements, for the purpose of constructing an internally lit ground sign with LED gas price modules. Application and supporting materials are available for review at the office of the, I don't have to read that, zoning department, located at 120 Main Street, North Andover, Massachusetts, on Monday and Tuesday from the hours of 8:30 to 3 p.m.
You don't need to read that.
Yeah, I know, I don't know why. Haven't done this enough. And we'll reference as part of the decision, the plot plan that was submitted by GPI dated July 14th, 2025, and the sign plan by Buckhold Signs since 1899, dated September 16th, 2025.
All right. Mr. Hatchie.
Aye.
Mr. Testa.
Aye.
Ms. Jacobs.
Aye.
Mr. Killalay.
Yes.
And I am an aye. You're all set,
Thank you very
sir.
much.
Have a good night.
Good night.
Thank you. All right. Next up, we have 12 Heath Circle. All right, Mr. Killalay.
Okay. Notice is hereby given that the North Andover Zoning Board of Appeals will hold a public hearing at the North Andover Town Hall at 120 Main Street, North Andover, Massachusetts, on Tuesday, August 18th, 2026, at 7:30 p.m. To all parties interested in the petition of Lawrence Welch for property at 12 Heath Circle, map 60.A, parcel 17, North Andover, Massachusetts, 01845, in the R3 zoning district. The applicant is requesting a variance pursuant to Town of North Andover zoning bylaws, section 195-7.3, table 2, dimensional requirements, for one side setback in the R3 zoning district for the purposes of constructing an addition, alteration, and remodeling. Specifically, applicant has requested a side setback needing a relief variance of 2.7 feet. The side setback proposed is 27.3 feet, and the side setback required per table 2 is 30 feet. Application and supporting materials are available for review at the office of the zoning department located at 120 Main Street, North Andover, Massachusetts, on Monday and Tuesday from the hours of 8:30 a.m. to 3 p.m. and Thursday from the hours of 8:30 a.m. to 4 p.m. By order of the Board of Appeals, Michael T. List, Chair.
All right. Please identify yourselves for the record.
Lawrence E. Welch, 12 Heath Circle, North Andover, Massachusetts.
Steve Prue, the builder, Fusion Construction and Masonry.
All right. Welcome, both of you.
Thank you.
And tell us a little bit about what we have here.
We're just going to put an addition on the front of the house. And so I guess it comes a little bit short, you know, because our house is on a circle.
Right.
So because of that circle, it's over. I thought it was 1.5 feet. I guess you're saying it's 2.5 when I just heard, but I'm not sure.
Yeah. it's
2.7
just over,
is
yeah,
what-
just
yeah,
over
yeah.
2.5 feet.
So the house is just coming out a little bit, you know, whatever, the addition.
And So why is it that it has to come out those extra 2.5 feet? Like, what is it?
Well, that's the addition dimensions that we had the architecture do without, because there was plenty of room, we thought. We didn't understand that the town actually owned a piece of our front yard, like on a circle.
That you had an easement there.
Yeah, I didn't know that. But now I know.
Right. So as you know, as the board, I think one of the questions that we always have to ask is like, why is it that this can't be conforming, right? So why is it that it couldn't be 2.5 feet less? Like, what does that do, practically speaking, to your plans?
Well, the building specs that we had, you know, my wife, she isn't here, but we had done in all the, I don't know how to explain it, but how we had the roof pitch and everything requires that
Okay.
additional 2.5 feet.
So if you don't, so in other words, if you didn't do that, then you would have to have a steeper roof, and that
Yes.
was not practically possible.
Correct, yeah.
Okay.
And it would drop an addition that's really only like adding 10 to 8 feet, so it's really not, it makes it a lot of it's a big deal if you can't get that 2.7, you know, from a builder's standpoint,
Understood.
yeah.
Is it, we measure to the easement or we measure to the property line? Because I can't read that plan.
I think we measure to the easement. Is that correct, Mr. Vanderwall?
You measured to the property.
To the property
line.
But the town's roadway, which is
Right.
always wider than what you see in
Right.
asphalt.
Yeah, it's not an easement, is it? It's the
Okay.
town's right
It's just
away.
the
It's
town's-
the property line.
Okay.
It's the town's property roadway layout.
Gotcha.
Right.
Oh.
When we first were over there looking at it, we thought we had plenty of room.
Right,
You know,
right.
like
Very
50
common.
feet. And then we were like, whoa, the town line, the property line, way over here. Once we had it surveyed, you know.
Yeah.
Yep.
And
Yeah.
that's when we were rightfully done by the request of the surveyor, you know, by the town. We were blown away by where the town line and his property line started,
Yep.
unfortunately. Which brings us here.
Any additional questions? All right. Is there anyone from the public that is here to speak on this particular issue? All right. Board members, I am taking your silence as you are all set to vote. Is that correct?
I'm trying to figure out where it was. I couldn't read that small plan.
I know.
So the addition.
Everything seemed tiny.
Oh,
Front corner, right?
yeah. Yeah. Thanks, Terry. Yep, keep going down.
A little further up.
Yeah, the line that says L equals 125.
This is the
Okay.
extension.
Okay.
Right.
So essentially, it's making the living room bigger. It's really not a big living room whatsoever. And when he has family over, that's the purpose, like Christmases, Thanksgivings, you know, holidays.
So we're dealing with the side, that side.
It's dealing with this
Oh,
setback
that.
here.
Oh, that's it.
Right,
Okay.
so this is 2.5 feet less because they thought they had out to here.
Yeah.
And they actually have
Oh,
to
okay.
here.
It's a lot. It's
Yeah, yeah. So it's just sort of like.
Yeah,
looking
it's not
across the
uncommon
street.
on, so, you know,
well, I never really dealt with it.
more modern
In
roads.
my career, I haven't dealt with the cul-de-sac with it, you know, especially being over that much of the front lawn. I was like, wow.
Yeah, no, anything since the 50s has a right-of-way that
Right.
is at least like 5 to 10 feet beyond the edge of pavement
Yeah,
for utilities and other things.
right.
You good?
I've been cutting it every week.
Send a bill.
All right. Are we ready to close the public comment?
Good, you want me to-
Go for it.
I'll make a motion, close public comment.
I'll second.
All right, all in favor?
Aye.
Right.
And I am an aye. All right, we are deliberating.
Really.
I think we're ready to go.
Yeah, it's a minimal.
Yeah. All right. Ready to read it in?
Sure, give it a shot this time. I make a motion to approve a variance pursuant to Town of North Andover zoning bylaws, section 195-7.3, table 2, dimensional requirements for one side setback in the R3 zoning district for the purposes of constructing an addition, alteration, and remodeling. Specifically, applicant has requested a side setback needing relief variance of 2.7 feet. The side setback proposed is 27.3 feet, and the side setback required per table 2 is 30 feet. And we will reference the plot plan by GPI dated 6/24/26. Do you think we need to list the architectural plans?
I do not think we need to do the
Yeah.
architectural plans.
Yeah.
All right.
GPI is on the plot plan on the last two projects.
All right, Mr. Ginsburg.
Yes. Aye.
Mr. Testa.
Aye.
Ms. Jacobs.
Aye.
Mr. Killalay.
Yes.
And I am an aye.
Thank
We're
you.
all set.
Thank you very much.
Thank you.
All right, thank you.
Have a good night.
Oh, sorry, do we have we need a second on the motion?
Second.
There we go. Thank you very much. Thank you, Terry, for catching me. Look.
Can I make a comment?
Yeah.
I do want to caution you, we can't issue you a building permit tomorrow. We do have a process of writing the decision and the 21 days appeal period that we have to go through. Once you return that final decision recorded at the registry, then we can issue a permit. But that's going to take at least 30 days.
What about with him? Does he have to throw a waiter or do anything with the deed and things like that?
No, it doesn't affect his property rights.
Okay, all right. Sure. Thank you.
Yeah, but they have to record the variance.
Yeah,
right?
we have 14 days to write the decision. A variance has to go to the city clerk. They've got 21-day appeal period. Then they have to take it, record it at the Middlesex Registry of Deeds.
Right.
North
You may want an attorney to
Essex.
record it.
I'm sorry, Essex. You return the recorded
how to do
stamped
it.
document that proves it's been, and then we can issue a building permit once we receive that document.
So when do you think actual building? If we follow all those steps and everything goes smoothly.
It's probably at least 30 days before
Probably
we can
30
actually
days.
issue the building permit.
All right.
Depends a little bit on some of the steps in the process.
All right, very good then. Thank you. And thank you again for all the help. Appreciate it.
Thank you.
All right, thank you.
Good luck.
All right. Our next item is 14, 16, and 20 Browns Court. Mr. Killalay, do you need a drink of water before you get started on this? Because I think what I'm going to suggest is that we read in all 6 items at once. No?
I wouldn't, only because the problem becomes if one or two,
They still vote on it.
We will vote on them separately. But I feel like we should have this discussion as a whole. But and open public comment as a whole, because I think if we go through 6 different periods of public comment, we will turn into skeletons and dust. So I'm going to recommend that we read in all 6 at once, but we will vote on them one at a time. So are you ready to do that, Mr. Killalay? All right, work your
Yeah.
magic.
I'd rather get a beer than a glass of water, though. But,
That's for after.
so we'll give it a shot here. Okay. Make sure I hit. Doesn't matter if I hit. I think I have them in order. 16, 14, 16, and then 20. Right. Notice is hereby given that the North Andover Zoning Board of Appeals will hold a public hearing at the North Andover Town Hall at 120 Main Street, North Andover, Massachusetts, on Tuesday, August 18th, 2026, at 7:30 p.m. to all parties interested in the petition of Centro de Apoyo Familiar. How do you pronounce that properly? Familiar. For property at 14 Browns Court, map 41, parcel 13, North Andover, Massachusetts, 011845, in the R4 zoning district. The applicant is requesting a special permit pursuant to Town of North Andover zoning bylaws, section 195-3 N1B, 195-4 3 N4, and 195-10.7 to raise an existing structure and construct a two-family dwelling. Application and supporting materials are available for review at the Office of the Zoning Department located at 120 Main Street, North Andover, Massachusetts, on Monday and Tuesday from the hours of 8:30 a.m. to 3 p.m. and Thursday from the hours of 8:30 a.m. to 4 p.m. by order of the Board of Appeals, Michael T. List, Chair. Do I have to like that last sentence every time? That last paragraph, application and supporting materials? Can I say it
I
applies
think you
to all of
can.
them?
I think you can do it once at the very end,
Okay. Just save us a little bit.
and I think you can just do the middle paragraph for each of them. Well, no, you,
I have
no,
to
you
say the
need
address.
You need the address. Yeah.
Yeah.
Sorry.
Notice is hereby given that the North Andover Zoning Board of Appeals will hold a public hearing at North Andover Town Hall at 120 Main Street, North Andover, Massachusetts, on Tuesday, August 18th, 2026, at 7:30 p.m. to all parties interested in the petition of Centro de Apoyo Familiar for property at 14 Browns Court, map 41, parcel 13, North Andover, Massachusetts, 01845 in the R4 zoning district. The applicant is requesting a variance pursuant to Town of North Andover zoning bylaws, section 195-7.2A and 195-7.3A and B, and Table 2 dimensional requirements for front setback, one side setback, lot size, and frontage in the R4 zoning district for the purposes of constructing a two-family dwelling. Specifically, applicant has requested a front setback needing a relief variance of 10.8 feet. The front setback proposed is 19.2 feet, and the front setback required per Table 2 is 30 feet. A side setback needing a relief variance of 4.9 feet. The side setback proposed is 10.1 feet, and the side setback required per Table 2 is 15 feet. Lot size needing a relief variance of 6,632 square feet. The lot size is 5,868 square feet, and the lot size required per Table 2 is 12,500 square feet. And a frontage needing a relief variance of 34.95 feet. The frontage proposed is 65.06 feet, and the frontage per Table 2 is 100 feet. Okay, on to the next one. Notice is hereby given that the North Andover Zoning Board of Appeals will hold a public hearing at the North Andover Town Hall at 120 Main Street, North Andover, Massachusetts, on Tuesday, August 18th, 2026, at 7:30 p.m. to all parties interested in the petition of Centro de Apoyo Familiar for property at 16 Brown Courts, map 41, parcel 47, North Andover, Massachusetts, 01845 in the R4 zoning district. The applicant is requesting a special permit pursuant to Town of North Andover zoning bylaws, Section 195-3 and 1B, 195-4, 3, and 4, and 195-10.7 to raise an existing commercial structure and construct a two-family dwelling.
Raise an existing structure, not a commercial.
Okay, thank you. To raise an existing structure and construct a two-family dwelling. Notice here, it is hereby given that the North Andover Zoning Board of Appeals will hold a public hearing at the North Andover Town Hall at 120 Main Street, North Andover, Massachusetts, on Tuesday, August 18th, 2026, at 7:30 p.m. to all parties interested in the petition of Centro de Apoyo Familiar for property at 16 Browns Court, map 41, parcel 47, North Andover, Massachusetts, 01845 in the R4 zoning district. The applicant is requesting a variance pursuant to the Town of North Andover zoning bylaws, section 195-7.2A and 195-7.3A and B, and Table 2 dimensional requirements for front side back, one side setback, lot size, and frontage in the R4 zoning district for the purposes of constructing a two-family dwelling. Specifically, applicant has requested a front setback needing a relief variance of 11.1 feet. The front setback proposed is 18.9 feet, and the front setback required per Table 2 is 30 feet. A side setback, we're needing a relief variance of 14 feet. The side setback proposed is 1 foot, and the side setback required per Table 2 is 15 feet. Lot size needing a relief variance of 7,202 square feet. The lot size is 5,298 square feet, and the lot size required per Table 2 is 12,500 square feet. And a frontage needing a relief variance of 40 feet. The frontage proposed is 60 feet, and the frontage per Table 2 is 100 feet. But first paragraph is the same.
Yep.
Right, so
Yep.
the applicant is requesting a special permit.
So this one is for
Or do we switch
20.
addresses?
We've moved
Okay,
addresses.
all
to
right, do
20.
have to read it, yep. I should could have skipped it in the last one. Notice is hereby given that the North Andover Zoning Board of Appeals will hold a public hearing at North Andover Town Hall at 120 Main Street, North Andover, Massachusetts, on Tuesday, August 18th, 2026, at 7:30 PM. To all parties interested in the petition of Centro de Apoyo Familiar, also formerly known as Bread and Roses Housing, Inc., for property at 20 Browns Court, map 41, parcel 34, North Andover, Massachusetts, 01845, in the R4 zoning district. The applicant is requesting a special permit pursuant to Town of North Andover zoning bylaw, section 195-3N, 1B, 195-4, 3N, 4, and 195-10.7 to construct a new two-family dwelling. Okay. And I'm going to skip the first paragraph, and I'm going to read the last paragraph. The applicant is requesting a variance pursuant to Town of North Andover zoning bylaws, section 195-7.2A and 195-7.3A and C, and table 2 dimensional requirements for front setback, rear setback, lot size, and frontage in the R4 zoning district for the purposes of constructing a two-family dwelling. Specifically, applicant has requested a front setback needing a relief variance of 17.1 feet. The front setback proposed is 12.9 feet, and the front setback required per table 2 is 30 feet. A rear setback needing a relief variance of 6.1 feet. The rear setback proposed is 23.9 feet, and the rear setback required per table 2 is 30 feet. Lot size needing a relief variance of 2,326 square feet. The lot size is 10,174 square feet, and the lot size required per table 2 is 12,500 square feet. And a frontage needing a relief variance of 60.99 feet. The frontage proposed is 39.01 feet, and the frontage per table 2 is 100 feet. Application and supporting materials are available for review at the Office of the Zoning Department located at 120 Main Street, North Andover, Massachusetts, on Monday and Tuesdays from the hours of 8:30 a.m. to 3 p.m., and Thursday from the hours of 8:30 a.m. to 4 p.m. By order of the Board of Appeals, Michael T. Liss, Chair.
All right. Thank you, Mr. Kellaway. Welcome back, Mr. Vaughn. Please identify yourself officially for the record.
Thank you, Attorney Brian Vaughn from Smolak and Vaughn for the applicant Centro de Apoyo Familiar.
Welcome.
Familiar.
I apologize, Frank.
Should have asked you before I started reading.
So, my client Centro de Apoyo Familiar, you may be familiar with them. Well, I guess technically at the time it was Bread and Roses. They were in front of you before. But Centro de Apoyo is a nonprofit corporation. It was founded in 2006 in Lawrence. It subsequently merged with and into Bread and Roses Housing, Inc., which is another nonprofit. That happened in 2024. And their mission, they're dedicated to assisting families with housing needs, and as part of its core mission, also they're now seeking to provide affordable housing opportunities, particularly to first-time home buyers. With me this evening is, on behalf of Centro de Apoyo, is Yukori Mello. She's the Community and Housing Development Manager, as well as Joe Levis of the Levis Companies, who's the general contractor for this project. I'll give you an overview of what we're proposing and discuss the project generally, but if we have any specific questions as to the mission of the client or some of the construction and design issues, we'd be happy to have them involved in the discussion as well. So obviously, I think it goes without saying that we have a number of variances and special permits that we're looking for. But I'm hoping that as I walk you through it, you'll think that it's maybe less egregious than it sounds when Frank reads all the notices. I think it's important to recognize here that we already have 3 existing lots of record with the existing lot size, existing frontage, and we had prior variances that reflect those dimensional requirements. And we're not seeking to change that, but we did apply to request variances just to keep it clear of record. The prior variance that was granted in 1982 was a single variance making reference to the plan of record, which had those same dimensional lot requirements, or non-conformities, I should say. And if, now with looking to have separate variances on each lot, which I think is the appropriate way to do it, we just didn't want there to be any confusion in the record. And since we were applying for variances anyway, we're requesting those variances, I would say, more as a matter of like have an abundance of caution to make it clear. So secondly, with each of the 3 lots, we're looking for a special permit to have a 2-family on each lot, and then we're looking for setback variances, variation of side and rear. I assume everyone's familiar with this area. It's 14, 16, and 20 Browns Court. Is a really small alley that breaks out off of Water Street, kind of across from the West Mill between Green Apple, and to the right is Green Apple, and to the left is a large, I believe it's like an 8-unit residential. And there's a couple of really old, dilapidated buildings down there, which are the subject property. And we're looking to raise and rebuild, and I think the plan really cleans up that area. It's going to be much more aesthetically pleasing and attractive. The proposal, which ties into the programmatic requirements of what Centro de Apoyo does, is to have a 2-family duplex, and it's to really service first-time home buyers. It's a consistent structure that they have tried to build with other projects. The existing setbacks that are there now are also required variances before. What we're proposing to do that's, I think, a little bit different and creates a more significant variance on what I'm going to call the middle lot is take it almost as a full redevelopment, deal with it holistically, and essentially move all 3 of the structures to the right, so that we're maintaining on the left side the required setback of 15 feet, which is improving the condition to the next nearest abutter, and then sliding everything to the right. And as a result, when we get to the middle lot, we have a very tight, almost a 0 setback. We're just looking for a 1-foot setback. However, that's enabling us to keep roughly 30 feet between each of the buildings, so that there's a more compliant kind of setback between the buildings from what it would be if we relied strictly upon the lot line.
And also to be clear, so other than that 1 foot, the next closest setback I think I see is the 12.9 on parcel C. And
Correct.
that one is from the Garden Street extension, right? And so that is a strip of unimproved land that is just basically grass at this point, right? But it's owned by the town. Is that that's the idea?
So, yeah, and that's actually, I should mention, before we decided to come to you and seek these variances, we really took some time to assess what we could do here. The history of it was included in my memo. I'm not sure if you had a chance to read it, but originally Bread and Roses, Inc. bought the house furthest to the right, came in, was granted variances for setbacks, to raise and rebuild that one building. Then, before they completed that project, a number of things happened. The other two existing structures, which are still standing, became available for sale. They thought it might be a good idea to kind of expand the overall project rather than doing just one lot, do all three. They also had their merger in between this time, and for a variety of reasons, then once they had obtained title to those properties, they started considering whether it would make sense to maybe do a different development here. And one of the things that they considered was maybe a modification of the subdivision, so that instead of just coming here and seeking a variance, that we would kind of shift all of the lot lines to the right, and two of the lots would become more conforming, one of them would become less conforming. And we went and had an informal discussion with the planning board about that, and it's a venture that would have been fraught with uncertainty, expense. It's a small project that couldn't afford it, and part of it relates to what you were asking about the Garden Street extension and where that lot line is at the end of Brown Court, where you can see it cuts over, and then you don't have a continuous access onto the Garden Street extension. Then you would get into discussion of subdivision approval and like the width of the way, and clearly there's no way of expanding the width at the beginning, but you get into roadway improvements potentially at the end, and it just, a project of this size and nature, this small, particularly with a nonprofit, it couldn't really afford that. And so we went back to the drawing board and said, well, we'll maybe try to see if we can get these variances. And again, knowing that one variance in particular with a 1 foot setback is something that the board might typically raise an eyebrow at, I think in the context of this entire project, and particularly the new variance standards that were discussed earlier this evening, when you're weighing the benefit to the community and the potential for detriment, I really think it does make a better argument to say, you know what, this development with these homes shifted over creates more green and is more appealing and really could meet that standard. So,
and these 6 units, will they be designated affordable housing, or will they be officially market rate?
No, they will be affordable housing. That is a question that I would think we should have you, Corey, speak to.
Okay.
So we can save that.
Okay, yeah, happy to save that one for that.
Yeah, yep.
Quick question.
Yep.
Because we're looking at 6 units. I'm counting a bare minimum of 12 cars added to. I've been down this. I remember in 2023 doing this, and I remember going down this alley of a road and seeing what that area looks like back there. And I approved this because we were talking one with 2, one structure, 2 families. So I was looking at that as 4 additional cars, which I thought even then was pushing it. But this is 12, and that's just assuming there isn't a teenager with a car in one of these. And that road scares me, because that road is more like a driveway than a road. And that's where my concern for the health, safety, welfare of the community, because that's coming out. I've been there. It's coming out in between 2 big buildings. And there's a sidewalk and there's traffic on that street.
It's a fair point. I will note that the plan does include a dedicated driveway for each unit that will have two spaces.
2 spaces for each unit.
A dedicated driveway for each unit with 2 spaces for each unit. So that's the plan. And then and secondly, though, I would say that I think when you have the prior use, particularly with the middle building that had multiple rental units in it, it probably attracted more more vehicles than this first-time homebuyer program will. And again, that's kind of a programmatic issue that I think we can ask Yukori specifically. They you know, their history with this product and
Well,
and
how
what they
many,
see for parking.
how many bedrooms are we talking in each one of these? I don't recall what we're looking at. Are we looking at 3 bedrooms, 2 bedrooms?
I believe it was 3 without looking at the plans. Is that right, Joe? 3, yeah.
And what are these right now?
So, right now, I think the unit to the left is a 1. The middle unit, I believe, is a 2, and the unit to the right was a 1. Historically, it appears as though it had been a 2.
So you get my point here. That I mean,
I do.
If where it was right now, if an argument you want to make is that potentially the people that have been living on this street have notoriously been having more cars, but it's been less bedrooms, that I feel like adding bedrooms is not going to alleviate the neighborhood's issue with cars. I mean, I had a hard time turning my SUV around on this street.
No.
Like, this is where my concern is.
I hear you, and again, you're going to have driveways with dedicated parking, which is off-street, and better access for each of those lots that presently exist.
Why didn't 20 Brown Street get dealt with? I mean, this is a 2023. Why wasn't, I mean, we're in 2026. We're more than halfway through 2026.
Yep. I think there's probably multiple issues. One of them was that it was acquired by Bread and Roses, then subsequent to obtaining the approvals was when the merger occurred and ownership changed. There's been a lot that has been going on with market conditions and financial situations in between. It was during that time period then that the other 2 units became available, that they acquired them and looked to a wholesale, like more comprehensive modification. There's a bunch of other issues with this too, where one of the things that was considered and discussed was, you know, gee, maybe this should all be consolidated into a 40B site. And again, too small of a project that it really wouldn't support the cost of that program, in our opinion. We recommended against it. There was another issue of like, well, gee, would this be a good site to consider the overlay district, which is right there? And frankly, it would have been, but for the fact that out of these 3 lots, I think it was only one of them fell within the overlay district, the others didn't, then it would have been a rezoning effort. So it was, all of these things were being considered during that time as to the best way to proceed. So.
Okay. This is what frustrates me.
Mm-hmm.
So 16 Browns Court was purchased in 2025. So if we gave the approvals in 2023, it is hard for me to grasp that we didn't do anything because we were working on making something more comprehensive when we didn't purchase until 2 years later.
So the merger.
Like, I understand the merger
occurred in 2024 between Centro de Apoyo and Bread and Roses. That was acquired by Bread and Roses 2023. It was then subject to the Permit Extension Act, so those permits were still in existence and extended out when they started considering other alternatives once they acquired the other properties. And also, I believe, and again, I wasn't involved at the time, but my understanding is there were some discussions with the ownership of the prior property. So it's not as if it just happened in 2025.
I guess I just don't put much weight on a merger. I guess I could understand more so if a company was buying, but I think a merger, I mean, you're just combining. I don't see where that creates this kind of a delay. Because at this point, everything we did, I mean, obviously everything we did in 2023 is now gone, it's expired, right?
Yeah, we
That's-
would.
That's why it's on
That's
for
why
now.
with respect to that law, we didn't apply to, modify the previously granted permit, we're applying for a new permit.
And then also back in 2023, the square footage, and I will be honest, I don't recall why this wouldn't have been an issue then and an issue now. The lot size issue wasn't addressed in 2023, because I looked back at the decisions.
Right.
Is there a reason why that wasn't addressed now and now that's being addressed?
So I can't state with certainty, there was the building inspector at the time, Paul, in his denial then did not deny it based on frontage or lot size. I don't know if Paul made the determination at that time that it wasn't necessary. I can tell you that in the interim, before we had our most recent change in building inspector, Paul had issued a separate denial, which the denial included lot size, but not frontage. When we applied for this one, we actually, with the, cooperation from the building inspector, had applied before the formal new denials were issued. He was in a tough spot just starting out his new job, and we were up against the deadline to get it in, and it's an important deadline for us because as a nonprofit, they have a funding round that's coming up next month, and it's really important that they get their approval so that they can seek their funding in the next funding round. And so in any event, we didn't have a denial issued. I don't know whether Scott would have made the determination at that time, similar to what Paul did the first time, to say, you know what, you don't need that, you already have those variances, they would still apply to this or not. So again, I applied for that out of an abundance of caution. The original variance, if you look at it in 1982, also just made reference to the dimensions as set forth in the plan. We're not changing those.
Okay.
I mean, I think personally, I actually kind of prefer it this way because I would rather than have that section already approved and then be adding these two. It's easier to look at them all as a unit. So I actually prefer it this way as much as it's created more paperwork for all of us.
Yeah, and I would, I guess should say on the record too, for your purposes, going back again to the earlier discussion about the change in the variance standards. One of the things that we are suggesting or proposing, if you look at the plan for 20 Brown Court, we have added a reference to a 20-foot use variance. And so notwithstanding that we're only going to have a 1-yard setback, we will welcome a requirement that it's conditioned on us granting a 20-foot wide use variance for the benefit of 16, which is the middle lot, just to, I mean, it at least ensures that you've got some further separation between.
But that's not us requesting that. You're already in these documents giving that to us. So it's not, whether you have to or not, it's something you've already put in. So it's not like we're adding on.
Yes, but there was
a
discussion whether
condition.
or not a condition could be required, and we're requesting that you do this.
Kind of makes it feel like you're giving us something without giving us something.
I mean, I think I would rather do it now than have to come back in a month after having requested that change.
We're putting our best foot forward.
I don't.
I'm sorry, is that easement already on the plan?
It is.
I mean, is your complaint that they have shifted it over and that they should not have, and that it should actually be 10 feet over to the right?
No.
Or to
What
the
I'm
left?
saying is that if the board is going to put a condition, it is something that the board either collectively at the meeting is saying, hey, this is what we want, or we're working it through with the applicant at the meeting. I don't like the idea of, well, hey, you're putting a condition by making this easement requirement when he's already saying we're doing an easement requirement. So it feels like giving dessert when you were already getting dessert.
I wouldn't.
That's what I'm saying.
I wouldn't suggest that we're doing it for that reason. But what I would suggest is that it's something which distinguishes and separates what you would be doing here, as opposed to someone else who came in and said, "Well, you gave them a 1-foot setback. We want a 1-foot setback." And the reality is, as a matter of precedence, to the extent that matters, you can say yes, but their deed restricted to this 20-foot buffer.
Attorney Vaughn, you've been around me long enough to know I would never give a 1-foot setback if my life depended on it.
All right. I think Ms. Jacobs has made her point. I know you have other folks that you want to have speak, and I also know it's getting reasonably late. Terry, I just want to say in advance, if you need to go, you can go whenever you need to, because I know you have to have a hard stop at 10 o'clock. Mr. Vanderwall, does that also apply to you?
Flexible.
Okay. All right. Do you have someone that you'd like to bring forward?
Documents for you guys just to see some digital rendering of what the street and the houses would look like once the project has been completed. 4 copies.
And please identify yourself for the record.
Hello, Gigauri Mello from Centro de Apoyo Familiar. I am the Community and Housing Development Manager.
All right, thank you. Welcome.
Thank you. Thank you for having me here tonight. We're excited about this project. As Alexandria had mentioned, we have had this project in our docket since 2023. I do want to address the time that took in between that original zoning meeting that we had and permits that were given and now. When Bread and Roses had purchased this house, they were going through a leadership transition, which had taken some time. During that time, they had also realized that they needed to merge with another organization due to the cost of operations. So that merger did take quite some time. Additionally, once we acquired Bread and Roses, there was quite a bit of other things that we had to put in order to make sure that the organization was running smoothly in other areas. We are a community land trust, which means that although all of the units will be sold separately, we will own the land, or will continue to own the land in perpetuity, meaning that the easement on the land, we still own the land. So all 3 parcels are still under, the land is still under our control. And so, as well as you guys know, in 2025, we also purchased 14 and 1618 Brown Court. As you guys know, that can take quite some time. So between between Bread and Roses leadership transition, the merger, and then the acquisition of 14 and then 16 and 18, that's where the 3 years has taken, as well as making sure that we had the correct plan for all 3 parcels, and that meant getting a new survey. We had to develop multiple plot plans, especially after we had spoken to the planning meeting and looking at our options, especially with our lawyers, to make sure that we were presenting the right options to you guys. So all that constitutes why it took us from 2023 to now to approach you guys for a new permit. If you guys have any questions regarding that, or is there any additional things?
Yeah. So I had asked Mr. Vaughn earlier about the status of the houses, that they will be designated affordable. And just so that I understand, does that designation exist in perpetuity? Like, how does that work?
Correct. So a community land trust means that we sell the homes, but we keep control of the land. Because of that, that means that the homes will be, we have a 99-year lease with the owners, and the house must be sold back to us before we sell it forward to the next owners.
Got it.
We keep the houses at a similar prices. We do adjust for inflation, but it's very modest. About 8% is what the guidance calls for community land trust. So the house will always be affordable, no matter how many families live in it. Bread and Roses had been practicing since about the late 80s. Since then, not only have they built about 38 homes, we have sold those homes on to other homeowners, and again, it continues to be affordable.
And, looking at the plans, they're all the same dimension. Are they essentially identical buildings?
It's the same exact building.
Yeah.
That is one of our goals as a nonprofit is to keep our costs down. So reusing the same model over and over again. One, we know what we're doing. We have built this house, especially our general contractors have built this house multiple times. It is a tried and true model, right? And as well, we want to make sure that the home looks well and that they match, right? So that it feels well planned and that the neighborhood looks well developed.
Out of curiosity, how many houses I don't know if you know this number, but how many houses has your organization built with this design in total at this point?
That would be a great question for our contractors.
Okay.
Our general contractors, they've been with us for about 20 years. Okay. But this model has been built multiple times. This additional material that I brought was a project that we did in Haverhill, where we built 7 units, 3 of them being duplexes, the same model that we're building here. We took down an abandoned church and its parking lot, and in its place, we built 7 units, 3 of them being duplex and 1 being a single-family home, with the same exact model that you guys are seeing that we'll be building here on Brown Court.
Is it a manufactured home or?
No, it's built on site.
Mr. Vaughn, would you be willing to turn that around so the public can see as well? I think that would be useful.
On the affordable housing question, does that go to our town's count?
I believe
Yes.
it does add to our SHI.
Correct.
Yeah.
And we are working with North Andover Housing Trust, and they have been financing some of our project, mostly acquisition. So all 3 buildings have been acquired through funds through the North Andover Housing Trust.
Okay, I didn't know if there was a formal step to make sure they're included, but
Yeah.
it sounds like you're doing something, whatever it is.
Yeah, we've also have 5 prior projects that we've done here in North Andover. They have been slightly different because we were renovating homes, but we have, out of the 5 projects, out of the 5 units, 2 of those units is a duplex, which is its model as well.
Where's that
That is on May Street.
And when the sale happens, is it sort of like a 40B where there's a lottery and such, or like how is the purchasing determined? And how does
It
that-
is a point system, so we
Okay.
do an initial meeting for families that are interested. They also must qualify.
Keep that down.
Which means that they have to qualify to make sure they're ready to purchase. So we do require a certain amount of savings. As well, we also require that our families are between 60 and 80 AMI. Families who live in North Andover get additional points, but it is open to the area.
Got it.
Our last 5 projects, all 5 units have gone to prior North Andover residents.
Any other questions?
Do any of these new laws that we just heard about affect any?
I was trying to
Of the
hear
variances?
closely to see if any of them did.
I know it doesn't affect the setbacks, right, but,
Yeah, no,
but frontage or,
I think it's just that the variance standard has has been lowered, where you have greater leeway to grant the variance.
Practical difficulty as opposed to.
Right.
Hardship.
And we're allowed to consider the need for housing.
But the duplexes aren't allowed as of right yet. They don't, that's the one that's
No,
may
that's
be
a-
coming, so
that's
so
special.
that doesn't apply. But did the lot size issue, because you've got lot size and frontage
For 20,
variances on here.
only 20.
Wasn't there something what we heard about
Yeah.
5,000 square foot lot size or 50 feet of frontage?
Yeah, but I think that related to particular.
That-
that was about
non-conforming
automatic lot
uses
mergers.
and- Right.
Generally
Right.
applies to unbuilt lots,
Yeah.
built lots.
So when you applied for this prior to,
Oh,
Mr.
did you
Tesla, do you have a
apply?
question?
He's asking if these were
these were applied,
prior to the law change.
No, the application was after.
so my understanding of, so I think that's 14, is that 14, right? The first one? Is the house gonna shift away from Water Street House
Correct.
to the right?
Correct.
So that, and so we're changing lot lines.
We're not changing lot lines, we are changing the distribution of the houses in those lots. Right, so Mr. Vaughn mentioned that they were talking about reassigning the lot lines in order to even some of these things out, but that was seen as a more arduous process than just going through the variances as is. Notwithstanding Ms. Jacobs' objection to double-digit variances, let alone 1-foot variances.
I was going to say, there's a foot, right? A foot.
I understand.
He's giving easements to create more space for the abutting lot without having to change the lot line.
I understand that, I just didn't know if he's moving that away from 60 Water Street, 69 Water Street.
Right. I think, as I'm looking at it, I think the existing sideline to the nearest Water Street abutter right now, there's about a 7-foot setback, and that's gonna change to 15.
Yeah,
Okay.
7
So
foot
it's-
1 inch, according to
Okay.
your own plans.
And, yeah, and then it's gonna slide, and then it's gonna leave, instead of having the, like, where it is now with the nonconformity closer to the abutter on Water Street, the nonconformity will instead be approximately 10 feet on the opposite side to our own lot.
Right.
And then the next house will also slide.
Yeah,
How many different designs did you guys go through?
as far as,
In terms of,
In terms of how many different ways did you guys try to fit? I understand trying to max out a lot. They're single-family homes, okay? So I understand trying to max it out. But how many different designs did you guys try in terms of, for example, 16 Brown Court? Was that this is a template we have, we're gonna plop it here, and this is how it works? Because I'm
no, I know
truly
that
questioning why
Joe Levis actually may be better to speak to that, because they did a lot of the design configuration, and I know that they looked at, trying to slide the houses in opposite direction, and no matter what they did, they were coming up with problems, and some of them were related to other things, such as like the parking and the programmatic issues, and a big part of it, I think, is also what Corey mentioned about their ground up development and trying to really maintain, for cost purposes, the model that they're
and I totally appreciate that. And the houses look beautiful, okay? But, and I appreciate that no matter what, you're gonna have problems. But I'm wondering and I'm looking and going, okay, we have, 34.7 in the front setback and a foot on the side. And then the parking, looking at the renderings, it's an alley driveway. So I think we all know that the street parking is going to be totally utilized.
I mean, realistically speaking, would you rather have a worse front setback to give more space from parcel C, which is one that they own. Would you really? Because, like, to me, if I'm forced to choose, I would prefer that you have as much setback as possible from other lots with other owners, rather than worrying about this lot that they already own.
I mean, they already own it, but they're not living in it.
No, but those people will buy it knowing what they're buying, right? Like if they don't want it, this is not being foisted upon
And
the
I
residents
appreciate
of
that, but I
lot.
still raise the question
Yes.
of making
No,
it,
this is that.
you know, not a foot
Because this
setback.
This one
Well,
is-
but that's my question. Would you prefer the trade-off, where instead of a 18.9 foot front setback, right, it's a 10-foot setback, in exchange for having 10 feet on the side?
I mean, I guess one of my things is, do any of those look any different? I don't know.
Yes, I view this as more, even though there are lot lines and setbacks, in reality, they own all the land. It's more like it's a,
They own all the land, but they're not living in it.
But those people will buy it knowing what they're getting.
It was as if they owned apartment buildings.
And
Yeah,
actually, they will own the
it.
land forever, right?
Yeah.
Like, they're not even selling the land, they're selling the right to live in the house for 99 years.
It's, is Browns Court a public road?
Yeah.
Or just the way that blue line is drawn on that plan, it looks like it goes out into the road a little bit, so I wasn't sure
It's
exactly
an
where the.
alley road, but it's a town road.
Is it officially owned by the town?
No, so I'm not 100% sure about fee ownership. It may be a private way, which this is part of, some of the issues which make a subdivision complicated. What I can tell you is that they have, without a doubt, a right to use the way for access and egress.
Well, does the town plow it and maintain it? And
Yeah, I was
pick
gonna
up
say,
trash?
who repaves it is, I think, the
Like who-
measure, right?
The
Is
town maintains
Well, all
it
maintenance
and does the
does-
trash and the plowing. I would,
Okay. Please come forward, please identify yourself for the record.
Leavis Companies, 158 Pleasant Street, North Andover.
Welcome.
Thank you. We've been working with Bread and Rosa, now CAF, for probably 25 years. And over the years, we've gone through a few plans. We've come up with basically 3 plans, one for a single family, one for the duplex that we're presenting here, and one is like a long, narrow one. And the one that we're presenting tonight, we probably built 25 or 30 times. It's, over the years, we modified it. It's super efficient. We actually, a few years back, they actually won an award for energy efficiency in Lawrence. When National Grid had a contest, they came in 3rd in the state, only because they were outspent. But they're beautiful homes. What's there now is 16 is actually a 4-bedroom. The house next door is a 2-family with 5 bedrooms, and the other one that was torn down had 3 bedrooms. So there was 11 bedrooms, and we're ending up with 12. That's the difference. The fact that they maintain the land, it doesn't really matter if it's a 1-foot easement. It's really, it's quality of life. In an ideal society, situation, we had an original plan, went to planning board, we had 3 equal-sized lots, and it worked out well. But they said, we can't do it. It was just, didn't make any sense. They told us to go to the zoning. So we're not moving any lot lines. We're basically moving the houses to make it best for the neighborhood and for the new owners, and parking. There's access easements basically for parking. And the fact that they own all 3 lots, the lot lines don't really matter, honestly, in reality.
I would argue that lot lines definitely do matter, because I
Well,
don't
if
think
you-
any of us know what 60, 70, 80 years down the road looks like.
They do matter if you're buying the house and you own the land. You don't own the land.
No, but I'm saying Bread and Roses might not, or whatever the company
Well,
name
Bread
is
and
now.
Roses, it doesn't matter. It's going to be affordable housing. If it's not Bread and Roses, it's not, it's a different age. It'll always be a nonprofit agency that's going to run it. They own quite a few units, and Lawrence, Haverhill, and North Andover. And this is their,
Well, and I know you talk about quality of life in terms
it
of.
really is.
Of new people coming in. I'm concerned with the quality of life for the people who are currently there, because this is going to truly impact them.
But what do they care about that 1 foot
Well,
setback on the lot line?
well, I think we have a decent sized amount of people here tonight who are showing that they do care, because it's 10 of 10 and they're still here. So obviously it does make a difference.
If I can also just, if I can just
Let's
add
make one point. For the last 40 years, these have been rentals, and they have not been well maintained. And it's been a tough clientele. This is going to be owner occupied. Huge difference. The neighborhood will change for the better, I believe. And, you know, they're looking for some help here. The town's behind it financially. They want it. They want these houses to come down. Everyone's kind of working together to get to the same point of, let's make this neighborhood a better neighborhood. And that's basically what it comes down to.
And
affordable.
I would just also add, though, like, because raising other issues with the butters, one of the interesting questions that came up when we were dealing with the planning board and when I was talking with the planning director was, well, why don't you improve Garden Street extension? Now, that, if you look at it, loops out between two of the abutters where there's a bunch of trees. And, you know, again, I said it earlier, this isn't a project that's big enough to support a substantial, you know, cost of clearing and adding roadway. But the alternatives to develop the lot would potentially be much more detrimental to the abutters by cutting through, you know, access in another area. So, you know, the other thing that I would say is that all of the directly abutting properties, for the most part, but for a couple, are a multifamily or commercial use, a similar density or more. Some of them are, you know, five units or 8 units. So it's not something that's inconsistent with what's there in that neighborhood. And then as far as the roadway itself and the access on Brown Court, it really, that access on Brown Court really services primarily these 3 homes. The front end of it is maybe used by some of the commercial property, but like in terms of the width issues or something that you mentioned, you know, they're the ones that are going to be having to deal with the tenants and the ownership and the parking issues down there between those 3 lots. And, you know, we think we have adequate off-street parking for it.
I think you're really underestimating the impact it has to the people around, because if it was an impact really only to these 3 lots that they would own, we wouldn't have as many people here tonight.
That's right. Is this the only 3 houses on Brown Court are these 3? There's no other houses on Brown Court?
Correct. I believe the other one's front on Water Street.
Right.
Or,
So there's no other cars that will be going in and out of the street other than the ones that
no,
are
because
residents.
I can't say that with certainty because it's
As a
we
public
don't know.
way,
Right,
sure,
exactly.
sure. But
and
I mean,
there
no
are
other
cars that
residents
park
that-
down along there. Like I know, like Green Apple or other people that come in and they use them, and they're going to be able to continue to do that. We're taking our parking and moving it off of Brown Court onto dedicated driveways for the 3 houses that are being built there. So it should improve, not make the matter worse.
I also wanted to bring up, we also have another project currently in Haverhill. It's also in a dead end. It's also in a very steep street. And one of the conversations that we have with the city is that we will be setting very clear parking limitations to the homeowners, making sure that they understand that they cannot park on the street whatsoever. Right across from our that house is also another house that's being developed by Habitat for Humanity, and they will also be putting the same restrictions on parking on the street, mainly because how narrow the street is. So that is not something that we're opposed to doing, to making sure that, hey, if the limitation is just 2 cars per home, then that's something that we
But
can address with the
How is that
homeowners.
how is that enforced? I mean, because we obviously know you guys aren't going to be driving by every single day or at 2 o'clock in the morning or what have you, right? So the town, if it's a public way and there's no parking ban, I don't see how a police officer can go knock on a front door and say, knock, knock, knock. You have strict limitations, you can't park across the street.
We do regular checkups on our streets. We also do keep regular contact with our homeowners. That is something that we do because of the land lease. They have to keep contact with us if there is any sort of breaking of any rule that we are aware of. We definitely do bring it up to them. We do not just sell the houses and everybody's off on their own. This is something that they have to be in contact with us because this is part of the program. We do ongoing education for our homeowners. So this is not a, hey, congratulations, we'll never see you again. This is a program that they're part of, and we do take very clear ownership of the need. If this is something that is very, if this is something that we know needs to be addressed with our homeowners, we will make sure that it is addressed and that is kept clear. No, we're not driving every night, you're right, but we do make sure that we do keep constant contact with our homeowners.
And now this is becoming out of pure curiosity. So you own the land, they buy the house.
Correct.
So now they break the parking ban numerous times, 5, 6, 7, 8 times. What do? Force them to sell the home?
I think that will be a conversation that we will have.
But
with
see,
the
that's the problem.
homeowners.
I can't, it's hard for me to sit here and feel like the justification of we don't run away once we sell the house, there are rules, there are restrictions, so on and so forth, but there's no consequences. Like, you can't tell me this is a consequence for violating, and not for nothing, I'm not really sure you can have a consequence, because like you've said, they own the home, you own the land.
Is that actually true? That I thought you said there was a 99-year lease.
Correct.
Right? So there's a lease agreement with terms. So
But obviously, the lease agreement doesn't say anything about parking violation consequences, or she would have been able to sit here and say, oh, well, there's consequences within the lease that state the lease is terminated after 5 violations of any kind.
Well, I mean, I guess we don't know yet if it's a public road, or, I mean, I've had projects where they're private roads and the whole property owners on both sides of the road over the center line. If that's the case, you could make some rule about parking. But if it's a public road, I don't think, they can't make rules about parking. What?
Do we not know whether it's a public road or a private?
I think it is, but there seems to be disagreement on that.
Private way.
Private way. So,
We did put enough parking. That's something that we wanted to make sure that each house has enough parking to drive. Everybody has a dedicated driveway that holds 2 cars. So that's something that we did make sure that was addressed on our plans.
I don't
But
even know if parking's an issue.
there's gonna be guests, I mean, they're gonna have guests, and
and listen, I don't even know if parking is an
it's
issue
better
for
that they
butters.
park there than on Water Street, you know, if they have guests and that sort of thing.
Some of these people talk.
Yeah. I'm shutting up.
No, I'm just,
I just, who does the property maintenance, mowing
The
the lawn?
homeowners are responsible for the property maintenance.
So they each do the half of the property that their duplex is on?
Typically, they end up putting fences up
Okay.
for the backyards.
Wait a minute. Wait, I'm sorry, where do they put fences?
In the backyard, so they have private backyards between the units.
Okay.
all right, I do want to give the community a chance to speak. I am going to ask that that we limit it to 3 minutes a person. I understand that that's not much time, but I also hope you guys understand that it is pretty late. So I am going to set a timer for 3 minutes. Who would like to come speak first? And please identify yourself, your name and your address.
How's it going? I'm Michael Ney, 2729 Garden Street. First question, so the 1 foot setback,
Yeah.
Is that against the Garden Street, my property, or?
No, it's against
Where's the
another
1
one of
foot?
the lots that they already own.
Okay, so then if I'm reading this correctly, the one against my property would be side, so it'd be 54.4 feet from the Garden Street. That's a setback?
So that, sorry, that's the setback, which one is?
The minute,
Which
so
address is
side
that?
B,
I
for
think
20?
The other one would be the 33.7.
Yeah.
Would be the 33.7, okay. And that's from the building or the driveway?
So that is from the edge of the property line.
Okay,
Oh, it's from the building to, yes, from the building to the property line.
okay. So I guess my other, just a couple comments. I appreciate what they're doing, what they've been trying to do for a while. I've heard a bunch of different stories about why it's taken so long. But one concern I have is if you go up there, if you go up Brown's Court at 7 a.m. or 7 p.m., I think Mr. Vaughn mentioned earlier that 69 Water Street is an 8-unit building. Those residents park all the way up Brown's Court, more than halfway. So that's just something to be wary of. Just getting emergency vehicles and whatnot up there. Plowing, everything else. I think that, like I said, I'm for it, and I'm not sure if this is the forum to mention this, and I know it's only 6 units. But if anybody's looked at Lake Kachikawick, and the average North Andover resident uses 65 gallons of water a day, and across 32,000 residents, that's roughly 2.1 million gallons a day. And as I said, you can see Lake Kachikawick's the lowest it's been in quite some time. So I just want to keep that in the forefront of development in the town, not just this one, but that's it.
All right,
Thank you.
All right, anyone else?
I'm John Morgan, 23 Garden Street. I own the building, 2325 Garden Street. Just a couple of observations. If there is another dwelling unit on Brown Court, maybe it has a Water Street address. It's across the street, basically, from 14. Is that correct? Is that recognized? Okay, it could be 57B, but it appears to be a house. I mean, it's a separate house with, several cars, so I don't know what the status of that is. And then I guess my question is, so these will be sold sort of as condos then, right? Correct?
Please address the.
Oh, I'm sorry. Okay.
No, that's fine.
Fine. Each unit that is being built is for 2 families.
Yes.
But they'll be sold separately to 2 separate families.
That is correct.
So in
Well, they'll
effect-
be leased, so it's a 99-year lease.
Oh, lease, okay.
But-
But they're.
Not the house,
No.
not the house, the land is leased.
The land is leased,
Oh,
but
the
the
le-
house.
ground lease.
Okay, I'm
They're-
sorry,
they're-
sorry. So the building is sold, the land is leased.
Okay, so I don't know if this is the right way of addressing this, but then that requires those 2 families in each of those buildings to cooperate almost like they're in a condo arrangement, correct? As far as
Sort of,
exterior
yeah.
maintenance?
I can ask more details about that after you're done, yes.
Okay. But otherwise, I mean, I think it's great. I think we need more affordable housing. I have granddaughters, as some people know here, and I wonder how are they going to afford to live in North Andover? So I'm all for it.
All right, thank you. So maybe you can help us with that bit of how the arrangement works.
Each of the homes are owned individually. If there is a large expense that covers both units, example, a roof, the neighbors are highly encouraged to talk about it. Again, most of our other homes, that's the way they work. If they want particular fencing, and they want to share that cost. Again, because these are affordable units, we really want to make sure that they're able to keep costs down. So anything that expense that they can share, they're able to talk about it amongst themselves. If there is, if they need additional support and come into an agreement, they can come to us and we'll help them get there. But both units are owned individually, and all the costs of maintaining utilities is covered by the homeowner.
I mean, my experience from living in Cambridge, which may or may not apply here, is living in a duplex, is that, you know, one member of that duplex, they could paint the house a different color up to the halfway line. Like, it's their property, they can do with it what they want. Usually you try to coordinate with your neighbor, but that's not necessarily a requirement. Would that be the case here?
I would say, but we are very selective of the people that we place in these units, not only individually, but as neighbors. A lot of our homeowners have great relationship with their neighbors, all the way from the first house that we sold in the late 80s to the latest houses that we sold in 22 in Haverhill. And they are very much aware that anything that would impact their neighbor, it's something they have to conversate.
Are they able to sell on the units to third parties without your approval, or how does that?
No.
They have to sell them back, you said that.
They have to keep it affordable, that's part of the lease.
So painting your half a different color, that's one thing, but a roof, I mean, you got a roof leaks on one side, it leaks on both sides.
Yeah, so we've had
It's saying
neighbors.
you might have owners who, you might want an agreement, but they might be in different financial situation at that point. They can't do it, but you still need a new roof. I mean,
and we've had.
because usually, I don't know, anytime I've been involved in something, there's been contractual language about whether it's a homeowners association or a condo documents or something like that, that would describe who owns what and how you have to kick in. So we want to make sure this stuff, doesn't end up looking like it does now.
Yeah, no, we definitely do, and there is, we go through extensive education before purchase and post-purchase of how you keep up a home. There's requirement of making sure your home matches and looks very well kept. If you drive around to all of our homes, you will see that they're very well kept. That's something we definitely emphasize during the home buying process. Before anybody can apply, we do a very extensive workshop of what is required to be one of our homeowners, and part of that is making sure that you maintain your property and what does that entail. And then again, we do have post-purchase education of how can you, if you need any sort of those projects, how can you finance it in ways that you can work as neighbors to make sure you're able to reach those goals. We've had plenty of our other homeowners change roofs, and that's something that they're able to change together. So instead of you having to pay for your roof alone, working with your neighbor to cover half of the cost is something that our homeowners have done in the past.
All right, thank you.
Sorry, real quick. Do you guys ever consider kind of selling them like condos with an HOA, where like the parking and the trash and the maintenance, that can all kind of be controlled, and there are consequences? Like the education's great, but like you mentioned, at the end of the day, you guys leave and kind of do whatever they want. And
this is our affordable home, so we don't want to add more costs to the homeowners. We are selecting families. So first of all, these are not being sold to individuals. The size of our units is for families. And we're looking for families that are earning between 60 and 80 of the area median income. So that means they don't have the opportunity to buy homes. So we want to make sure that if we're giving them the opportunity, they're able to maintain it. And part of that is lowering our costs as much as possible. So adding an HOA would raise that cost, and we don't want to add to our families who we already understand their financials. We're making sure they have good credit. We're making sure they know how to save. There's a lot of requirements that they have to meet. That just because you show up to a meeting doesn't mean we're going to accept your application. This is not a lottery. It is a very extensive process. There's very clear requirements, and additionally, there is also an interview process. So we do go through quite a bit to make sure we're selecting the right people to move into, the right families, and then making sure we're giving them support, enough post-education to make sure that they're doing the right things with these homes.
All right. Would anyone else like to be coming up to speak? Please.
Hi, my name is Heather Norwood Cole. I live at 73 Water Street. My partner and I live upstairs, and I have a business downstairs. I really would like to say that I really would like to see something done with Brown Court, but on the other hand, I'm really concerned about the ability to use that road properly by fire, ambulance, and there is right now not much of a turnaround at the top of that street. There's plenty of people who are parking there that live at the building that is on Main Street. There's probably 1, 2, 3, 4, 5 parking people coming in and out of Brown Court continuously all day long. I don't know if you received my paper in your inbox.
Did, yes.
I don't want to sit here and bother you with all of the stuff that's on here, but I would like to get some of the answers to these, but I know we're late and I don't want to take up all your time. It looks like the 3 units that are there, there was 4 parking places, and only 2. Are these parking places in front of each other so
They're-
that they can't get out, or are they side by side?
It's alley parking.
It's alley
Tandem.
parking. That is very difficult, and people don't like that. They tend to park elsewhere, and already Water Street is extremely congested. Brown Court is extremely congested. There's 4 cars up there already right now, with 3 cars at the end that are unregistered and owned by someone else. Will there be anything done to the infrastructure of the road of Brown Court right now? Anything? Nothing.
Not based off of from the
It's
applicant.
in very poor condition. It's very hard to plow. You can ask the plow driver who's sitting right there in the front row, who is very, very hard to plow. So, trash pickup, there's been lots of problems with other issues that I've already had spoken to the health department. Will there be proper grading of the ground drainage to eliminate flooding of existing neighbors and properties on Water Street? Will there be privacy fencing installed around the property or on the back of the property? Will there be rules on how many people that live in each unit? I've got way more, and I don't want to take up your time for this evening, but I'm very concerned about what will happen up there. Would I like something done? Most definitely. It's really been pretty sad up there. But it needs to be done right. I need to be able to have a fire engine go up there. We're really compacted down there, and if we don't have the ability to get a fire engine up to that 3rd lot, and we're gonna lose a lot more houses up there if there's a major fire. So those are my concerns, and you have the other piece of paper that I left you. Thank you very much.
All right, thank you. All right, next.
I'm Cindy Robinson of the Green Apple Cafe, and I know Joe very well. So I do agree with Heather that there very much needs to be something there. I mean, there's been squatters and to some degree drug needles, people changing their cars out, like something needs to happen, trash blowing. But there is a parking issue, and definitely the winter is very, very rough on that street. So I agree with the project itself, but in listening to this, it's causing that open wound of the parking a little bit. Yes. So I don't want to relate to you. Yes, I know that you're my plow driver. Yes, so he often will get stuck on that road. So I mean, something has to be done majorly in terms of the town with that, because it is very tight. Like, you spin out going to the top, don't you? Yes.
Can't turn around.
You can't turn around. Yeah. So that I do witness. Yes. So I don't know what the town can do to support it. I don't know in terms of the snow, but that's a big thing. Yeah, because during that big snowstorm, you couldn't even get up there till.
To the loader king.
Right, right. So, that's it. And as far as everything else, there's a trash truck that comes up between the two driveways of 60 Water Street and 14 Brown Court. It's a shared driveway. And that's an easement at the end. Let's see. I'm going to fill in all the blanks here. Yes, so I do think that it's a very good project, but it's a control issue again. I don't feel like there'd be any more cars, but you never know that are already on Water Street causing, as I'm flailing my hands, problems anyways, because there's just all of those apartments across the street that have parking that actually park on Water Street. So, I mean, it's a problem everywhere there. You have any questions for me? I think it's a very good project. But
So, you plow this, I guess, does he plow the street?
he plows Brown Court and then he
For
plows
the-
the driveway of the Green Apple.
So do you plow the street for the town? Or
Yep, yep. And I'm the one that has to plow it, because the town truck won't go up there. That's how bad it is.
Right, so the town pays you to plow the street?
Yeah, I'm private contractor.
So Mr. Vaughn, I can tell you.
Okay, so, yeah, you should be at the podium, but we can address that later. Sorry, go on.
I can tell you right now, hearing about this road, I want to know from fire whether or not, because I understand there are houses up there already, but I'm not going to continue a bad situation. I want to know if a fire truck can get up there, and if an ambulance can get up there, and if they can get out, because
They can get out, but they have to back, a lot of times they have to back out. They
you have to,
don't-
so you're not turning around up there, you're
They
backing out.
haven't
the street.
because the telephone pole across from 14 Brown Court has, well, I won't say caught fire many times from a squirrel, but it has. So they have had to go up there and they usually will back out. But I mean, they're only kind of at that spot. I don't think they've gone up further. But there is kind of a big turnaround there too, if you get to the end without the snow. I mean, it's not great, but yeah.
All right, thank you.
I don't know.
All right, next up?
Wait, one more thing.
Oh.
One more thing. You know, there has been a lot of damage to the neighborhood, to particularly this house, of people, you know, hurting in the area. So, I mean, you know, I think it's a very good thing, but like, you know, with anything, control, but it's one of those things.
All right, thank you.
All right, thank you.
Yes, sir.
My name's Ted Colin. There's a rat problem up there nobody knows about. Ever since they started screwing around with those houses on Brown Court, the rats come through my yard, you know? So something's got to be done about that too.
Do you live up in that area?
Yeah, I live at 58 Church Street. Behind.
Gotcha, okay.
So something's got to be done about that. Nobody's even thinking about that. And McPhee hot topped that road, I'm almost sure. The guy that used to own the property, McPhee. All right? Thank you.
All right, thank you. I mean,
So it
maybe,
would be
maybe
good-
this is a
it would-
question.
oh, sorry.
Maybe this is a question for the builder, but I would presume that part of the reason that there's rats in that building is that the building is not in great shape, and that if we clear out the foundation and build a new structure there, that would be an improvement on that long term. Is that a reasonable description?
Yes, it is. And actually, when we go to tear those down, we have to hire an exterminator to put out rat traps prior to, for a couple of weeks. He has to check them and get certification to the town as part of the application to tear the houses down.
All right, thank you.
Yep.
But I was gonna say, it sounds like it is a private road. Seems like we should get a handle on who owns it.
McPhee, used to.
Well,
Mr. Vaughn, that might be a
we
question
should
for
find
next
out
week.
now who won't, because
Yeah, but
you
so-
might have maintenance responsibility for the road.
If it's a private road, it doesn't really, I guess, change the analysis of we have access rights over it and to use it, as do all the other abutters, right? What the question becomes is, you know, and I guess the second thing that's kind of interesting, and, you know, we want a comprehensive solution for everyone, right? But there's, you know, right now we have 3 existing residential lots, and, you know, in theory, we rebuilt the homes. We still have the same, you know, access rights to these properties. Brown Court is basically a 10-foot wide alleyway. And so when people are talking about parking down on Brown Court, when you get to the end of Brown Court, you're basically at what is Centro de Apoyo's property, or there are a couple of houses on Church Street. I think the funeral home abuts to it. Then there's the Garden Street extension, which was undeveloped roadway, and I believe probably both abutters to that own to the center line as a guess. But for all of the parking and other issues at the end of this roadway, I'm not sure that there's anyone else that really has ownership rights to be parking their cars there. They've got a right of access and egress over the 10-foot way. So I'm not sure why it would be Centro de
Relevant to
Apoyo's
decisions.
nonprofit obligation to improve some parking area on land
I'm-
that
No,
they
but you
don't
should,
own.
I guess, I'm just saying, you should understand
Yeah.
who owns it and what that ownership responsibilities are.
Yep.
I've seen a variety of private ways.
And I agree, Frank, and I
because-
think in
because you
common-
might be responsible for paving it.
I think they have the
And you
right
haven't
to
factored
pave
that-
it.
Well, you-
I don't know that
well, you-
they have the obligation. They
Some-
also would have,
But, well, sometimes I've seen it's agreements, if the funeral home owns to the center line, or they own to the center line, there may be some language, in a deed somewhere about what their responsibility is for maintenance. And they should just.
yeah, and I didn't see any.
Okay.
You know, and again, I didn't handle the acquisition, I haven't done the full title search, but the research that I've done, I've seen the right to use. I haven't seen any maintenance agreement on it. I would think that it might make sense for all of the neighbors collectively to discuss, hey, let's have some, you know, cost sharing, let's improve this. I mean, I don't know that.
Well, I can't imagine
the
a funeral
opposition-
home will give a crap about doing it.
Yeah, and they don't use it either, right?
Right, so
Yeah.
that means you'll be paying the whole cost, you
Yeah.
wouldn't be sharing it with anyone.
Yeah.
So you just should understand that.
My bigger concern at this point is, at the current moment, the way it stands, nobody's living down at the end of the street. I mean, if there's squatters, there's nothing you can do about that, but nobody's living down there. You're now asking for us to put 6 families in there. I want to know if a fire truck and an ambulance can get down there if a kid's choking or a house lights up on fire. And I want to know that a kid can get to an ambulance. That's what I want to know, because right now, that's not a concern. I'm not asking for your client to improve the road and expand the road if the fire department comes back and is like, nope, you can't get anything down there. Not, you know, I'm not asking for you to do that. I'm not saying that's your responsibility, but that is a concern.
Well, it sounds like they can get down there, they just might have trouble
Isn't
getting
that-
out.
I mean, isn't that an existing issue? It's not whether they own it or the previous people own it. It was a lot, it was a house. Someone was living there, and someone at some point made the determination that fire truck could get there, right? So whether it's, I mean, the buildings on Water Street haven't changed. The roadway is the same, Brown Court is the same width it
Except for-
was.
That might not be true, because and I can't remember, there's always been that big, huge apartment complex on Water Street for as long as I can remember. But Water Street in that area has picked up more than it was 20 years ago. So whether or not that street was being used, and again, we're talking alley parking. So let's just go with husband, wife. Are we really talking that husband's gonna move his car when wife wants to go to the grocery store and all of that? That's not gonna happen. So
Well-
now are we parking in front of the house because Water Street is already parking on Brown Court? And now we have a fire truck that needs to come up, or an ambulance.
But right now, you have well.
But they're not.
Let's say 10 years ago, you had 3 houses with 11 bedrooms, and people were living there without driveways, without places to park, and you still had the ability, or you should have had the ability for an ambulance to get up there. But I don't think it's the responsibility of the property owner to make sure that the road's wide enough for a fire truck to get up there.
Whoever allowed for that in the first place, I won't give my 2 cents comments, but I'm not going to make a bad situation worse.
All right, can we let more folks from the public speak? Is there anyone else that would like to come speak? There are a few more folks that haven't spoken yet, so I just want to make sure we give them an opportunity. Okay. All right. I think the question is, at this point, because Ms. Jacobs has argued that she would like to hear from the fire department before making a decision. I don't know, I can't read your mind, but I don't know if that is actually going to change your mind on what your decision is.
Listen, I put a lot of weight on the public. I do. But, and they don't seem to have as big a gripe with this as I do, which is really what matters more.
Okay.
But at the end of the day, the safety aspect is still a huge nut of mine.
I just asked you, Tori, and we would be willing to agree to a condition that we would repave Brown Way.
That what?
That we would repave Brown Way.
Brown Court.
Brown Court, excuse me.
I swear I'm not trying to be difficult.
No.
Attorney Vaughn, I'd like to be difficult at points, and I'll take that 1 foot to my grave. But it's not so much the fact of paving. I want to know if it's, and I don't know how it gets dressed. I don't.
Well, I mean, I would just say, to Jim's point, that, we do know that houses have been there since like circa 1900. Look at the assessor's cards. They were built, they were existing. I have seen them on very old plans at the Registry of Deeds. It's provided adequate access for residential homes for time immemorial. So we're not substantially increasing the density down there from what's historically been used. And I appreciate where you stand. I think that us offering to take the full expense of repaving Brown Court should more than solve the concern that this board might have.
I have a question, and I don't.
When I brought that up, I wasn't trying to push that on you. I just wanted you to be aware that you might, financially, that might be your responsibility, but I wasn't suggesting that.
No, it's fine, and we've heard the abutters speak. We think that it's a good thing for everyone. It's a good thing for us and for our tenants or future owners. We don't have a problem with paving it. I do think that maybe it's still a good idea for the neighbors to get together with us and talk like, gee, how can we improve the rest of this? But I don't think that's solely our responsibility. If there's a way to widen things, great. I think we'd be happy to do that, but it just can't be a condition. We can't control that.
But here's my question, and this is going to be for you and the commissioner, because I don't have the answer to this. If you go to the fire chief and say, is this street good? Like, we're okay in terms of emergency vehicles, and he turns around and says, no, I can't get a fire truck down there. Like, sorry, you're out of luck.
No.
Does that impact their ability to be able to build something there? Because that's what because my fear becomes, let's assume, and I don't.
I can say though, like, and Scott can disagree with me, perhaps if he thinks I'm wrong, but I think you've got the existing residents that are there. I don't think that the town can tell us, no, you can't rebuild those. I think that we have a by right ability, but that's for what's existing.
Are they condemned?
I would also say though, like, there was mention of this situation, condition, what it is. I mean, I grew up in Lawrence, and there was probably, 10 feet between houses. This is not very uncommon in downtown areas for emergency access egress. There are a lot of places that don't even have driveways and don't have this much, and you're still fighting about parking on the street. And
Lawrence would hate me. But my concern is the citizens of North Andover.
Mhm.
And Lawrence functions differently. They are a city. And like I say, they would
Yeah.
hate me because my question becomes is a lot of people aren't paying attention to things when nothing's going on there. So if this gets approved and it starts going through the permitting process, fire has to sign off on it, right?
I mean, okay, hold on. Let's say for the moment they object. Let's say for the moment that our building inspector says, I can't grant you a permit. That will then force them to come back here, right?
Right, and I don't want to go through this for another 4 hours. I don't think they want to go through this for another 4 hours.
But then if you make them, say, talk to the fire department and come back next month, then we're going through it for another 4 hours, right? So
Why?
you're asking to do this all over
Why?
again.
Why are we going through it? Because one of the things I'm hearing from the public is that they're not really psyched about the volume that's going to come. However, it is going to be better than what's there. But here are some concerns. And one of the concerns I'm hearing is, yes, there's the parking, which aside from what they say, they have zero control over it, and the police have zero control over it. So from that point, I go, emergency vehicles. I don't think that is a big ask. And if they come back and the fire department says, no, I can't get a fire truck down there, so no, it's not going to pass the process.
May I?
Yeah.
So again, in Haverhill, we have our project, very narrow street, at a very steep. One of the things that we came in agreement with the fire department was to add sprinklers to the building so that is not an issue in case of fire. So that was the solution we came up in Curtis in case, and it was approved by the fire department. It makes sure that there's safety in there, especially for fire. So that was something that we have addressed, again, in the project that's happening right now on Curtis Street in Haverhill. So if that is one of the concerns, that is one of the solutions that we have come to in Haverhill.
Could the police department
Please come to the podium. And I'm going
But,
to make you identify
You're
yourself.
selling affordable homes here, so I don't want to.
Heather
I don't
Nolan,
want these
73
decisions
Water
to
Street,
push
North Andover.
extra costs.
Right now, the police department won't even go down that street. They will
Why?
not drive down it. We've asked for them to go down to take care of some issues. They won't access it. They feel that they may be ambushed, are the answers that I'm receiving from them. They have done foot patrol and bike patrol, but I haven't seen anybody go up that road in a really long time. The police are always here. They're here constantly, so it is a safety issue for this whole area.
We did-
Please let the applicant speak.
Yeah, we did have a squatter issue, which is why we've boarded up the homes. And in order to make sure that when we went to address the squatters, I called the police. They happily joined me there. I had about two cars that were up there that escorted me into the houses to make sure I was safe. And it was by their recommendation that we decided to board up the houses, but the cops did join me on the street, and there was more than one car.
All right. I want to gauge the board's temperature here because I think Ms. Jacobs has made her point of view clear. Do other members feel that we need to continue to another month? I am personally not willing to postpone this over this particular issue. I think I would rather vote now, but I want to.
Well,
I would like to, Heather submitted these questions, and we haven't sort of gone through and asked them.
Okay. I mean,
And
yeah. I mean, I felt like most of those were outside the scope of what this board should do, but I think there's a couple like about.
Well, this is her only opportunity to have them answer.
Well, she came and spoke.
Yeah, and she asked some questions that
yeah.
we
But-
didn't necessarily
but-
respond to.
So
well.
one question was about privacy and privacy fencing. You mentioned that is up to the neighbors, that is not something that you guys plan to install from the get-go.
Well, do you?
I think, is that a reasonable?
Well, you said they run a fence down between their property line, but do you install one along the rear of the property?
If that's necessary, everything is predetermined, so if that's something that's necessary, we can add it to our budget, make sure that we get additional funding for it. The reality is that our next round of funding is coming now in September. One of the big issues why, and one of the reasons why we weren't able to get the other project up and running was because our project is not what funders consider shovel-ready, meaning that if they give us the money, we should be able to go. One of the biggest things that they brought up was zoning. Without zoning, it doesn't make sense for them to give us. So postponing this another month would mean that we are literally losing funds to be able to get this project up and running. So if fencing is necessary, we will happily add fencing to our budget and make sure we get the additional funding needed to make sure that we have privacy fencing. As long as we're willing to work with you guys, as long as you guys, because you guys are willing to work with us. If that's something that the neighbors are asking for, we will happily abide. Again, that would just mean us making sure that we have the correct funding to make sure that those fences are placed.
It was additionally asked how trash pickup's going to work. Is that going to be individuals or is that going to be a communal?
Yeah, no, that's individual. It's trash and sewers.
Town trash.
Yep, exactly. That's
And is there any external lighting that comes with these buildings that's going to be cast outwards at all?
Again, that's something that we can discuss during the construction. Anything that needs to be adjusted, we will happily adjust. Again, we want to make sure that the homes are great for our homeowners, and if that's something that needs to be adjusted, we will adjust.
And I assume in terms of demolition, for asbestos, lead, things like that.
Oh, that will be tested before we do any of that. That's what we did with 20 Brown Court. We did have asbestos, and we did do remediation. It is part of our budget to do asbestos and lead, all of that. I do want to note that we did a phase 1 environmental for the existing building, and they both passed. There was no issues. There was no asbestos. That is a separate thing that we are planning to test once we get to the demolition phase. That was already done to 20, and the remediation happened for that building.
Well, you'll need to have that testing to get a demolition permit.
Correct.
But I guess the point that they were asking is that you would have the proper controls, so you'll test. If you don't test it, and you just tear it down.
We can't even
it's gonna
demolish
get in
it.
there.
No, that's part of the demolition process.
Yep. They also asked about your timeline for the construction, and days of the week.
Once we're able to start construction, it is a 6 to 7 month project, correct? And that was tested in the large project that I.
6 to 7 months for all three?
The project in Haverhill with the 7 units, they were able to complete it in. Yep, and that was 7
And
units.
you work just weekdays, or you working weekends?
Sometimes on Saturday, maybe 2 weeks.
So Monday.
They were on Sunday.
Okay. They asked about grading for controlling the drainage. Apparently, there's some.
Please come to the podium just so it can be.
So all the homes will have gutters and downspouts, and we actually have a retainage system on each site, so no water from the roofs can leave the site. It's all contained on the site. It's called a Caltech system. It goes under and it just drains naturally back into the ground. It's like a French drain.
Right, but how is the yards pitched and whatnot? Is that?
They're fairly level. The backyard would be, fairly level. And there'll be grass. There'll all be grass.
Okay.
Come on, going uphill.
Is it pitched to shed off of the property, the lawns, or towards the Caltech system?
The Caltech system takes care of the gutters for the roofs.
Okay. Will the large tree at the back of the property be removed?
Probably.
Yeah, and on the lighting, do you put up like a light post at the, front of the driveway or that sort of thing? just to light up?
Everything's mounted on the building. That way they don't get knocked over when people are driving around and plowing and so forth.
Yeah. But there's no more, you're not putting any street lighting or that sort of thing in?
No, there'll be lights on the porches, usually recessed in the ceilings. There'll be floodlights on the side to light up the driveways, and usually a floodlight in the back for the backyard.
Okay.
They'll all be LEDs.
Okay. I think that addressed any of the questions that Heather had asked. I don't know how she feels about their responses.
I just had a couple of things to tie it in. The Blue House had a squirrel problem that contributed to the telephone pole that has been fixed. I do think the area is unsafe now, so definitely this would be safe, even with a couple of cars. I've watched the garbage trucks back up, the vehicle knock down the building. Everything goes up and down. It's just, they just necessarily go in a different direction. But I think the problem is at the bottom of Brown Court, Water Street, that parking space, particularly on the right, that I would love to have handicap, I'm just saying. I think that would open it up, but anyways, no, the present condition is, when I hear these things about two different color houses, well, the house is bright blue that I've been looking at, you know what I mean? So like his shirt. But I think overall, it's a good project. Listen, I control that neighborhood as best I can, and there have been wild people there, so I don't think, to Jimmy's point, that they would be controlled in a certain way, so. Trash hasn't even been bothering to come up the street because it was just me putting out. So that will be back to normal. Anyways, I think it's a good thing. I don't know. I'm just putting my 2 cents in. Will it affect me? Probably, but I say go for it.
All right, thank you.
All right? Thanks.
All right, on that note, given the time that we are at, do the board members feel comfortable moving to deliberation?
I'm not voting.
I think you're going to vote for half of this, so I'm gonna go.
Well, that's
If
true.
we're gonna go
Go back
item
and
by
forth.
item, we're gonna go back and forth between you. So, I hope you've been paying attention.
Then yes, I'm comfortable. I'm comfortable.
Don't forget, you work for us. She's the only one that's on our side.
All right.
I didn't know we were working.
Do we have?
You're not
I don't
paying
see,
us,
I don't
though.
see a paycheck.
Do we have a motion?
Close public comment, public hearing.
Second.
All in favor?
Aye.
And I am an aye. Ms. Jacob, do you abstain?
I've spoken my piece. I think the fact that they are on a timeline is unfortunate, but for whatever lack of planning does not mean that I'm going to give up a concern that I have and a concern that the neighbors have. So I'm not really sure I'm in a position to sit here and say, you guys should put X, Y, and Z condition. But I guess I hope that an ambulance or a fire truck never needs to go up there.
Well, I mean, I'm willing to ask them to put sprinkler systems in the house, so a fire truck, and if a trash truck can back up the street, an ambulance certainly can get up the street.
I mean, I feel comfortable with allowing the fire department to work out whether or not a sprinkler system is necessary.
That's
I don't think we need a. Yeah. Right, so they're gonna have to approve it anyways.
The one thing that I should have asked before we closed public comment was if they choose to pave Brown Court, does that then make them liable for maintaining it?
I mean, I think they already are.
For the future, right? So
It's a private way, it sounds like, so they already are to some extent.
and if it is a private way,
There's a huge variety of maintenance responsibilities.
But the town's plowing it, so I don't know. I mean, it sounds like the
so
town.
it's a private way.
takes
The
some
town's
responsibility
plowing
for
it. They're picking up the trash. I don't know if it is a private way, can they control who parks up there, who doesn't park up there? If it's a town road, public road, then anybody can park up there. But if it is a private road or a private way,
I guess another way to view it is, does your yes vote, or does anyone else's here's yes vote, ride on whether or not we ask them to repave that road?
No, mine doesn't, but listen, from what I'm hearing from the neighbors, there's not anyone that's dead set 100% against it. I mean, they all want better for the neighborhood. I think it's better for the neighborhood. They're providing 2, 4, 6, 8, 12 parking spots, right, for the houses, and which is more parking driveway than they have now. And to me, the access to the street is existing. There's 3 houses there. Whether they build a duplex or they build a single-family house that meets all the setbacks and everything else, and they're 100% can just go pull a permit, the fire truck still may or may not be able to get up the street.
Yep.
So that's my take on it, I guess.
I also think, if the fire department has their concerns at some point in time where there are too many cars parking on the street, then the town's gonna have to have something to say about it. And maybe there end up being issues with, more cars parked on that street, and maybe the town has to do something about it. But, it's clear that the project they have in mind and the thought they've put into it, the fact that it's tried and true in other areas, I think the intention behind it and the fact that they've done it numerous times beats the hell out of 2 derelict, buildings and rats running around everywhere on that street. So that's where I fall on this.
Mr. Hatchie, any thoughts?
Yeah, I mean, it's definitely, sounds like it's an improvement to what's there. Like, I think there are some concerns with, like, access and stuff like you mentioned, but I think down the line between building permits and whatnot, if there is problems, they'll be dealt with then, and they have to come back here and do it again, fine, it won't be as long as this, but I feel like we shouldn't create an issue if we don't know there is one yet, especially with the private way versus public way. Like, it sounds like we don't have a definitive answer on that. I think overall it's definitely an improvement, creates more housing. There wasn't as much pushback as I was expecting by the neighbors. It sounds like they want this just want it done right. I think that's kind of their goal as well, so I'm okay with it.
Mr. Killalay, any thoughts?
Yeah, I mean, I was mostly concerned with the neighbors, and most of them seem to be saying they'd rather see this place cleaned up, but again, they don't want it creating more problems. I think a lot of it is just the parking in that area in general, and it seems like the town doesn't do much parking enforcement there, and for whatever reason, that might help out if they did. But I think that could definitely use a cleanup and some additional housing.
I think in looking at these very legitimate issues and the fact that this road is not ideal in a lot of ways, I think we miss the forest through the trees sometimes a little bit, in that this is kind of a unicorn, right? Like, we just went through a 6-month 40B. And the thing that I heard from neighbors over and over again is this is too big, way too many units. Why can't it be smaller? And also, why can't it be 100% affordable? Right. This is 100% affordable. All of these units will be affordable forever. And it's creating new homeowners, which is wonderful. It's a lot, it is as a block with a housing design that we know works, that's going to be easy to maintain. I think there is so much to like about what this has done, and I get the point about a foot setback, but I don't think I would choose any other orientation. And so then the only question is, do I feel it's important enough to make them go to the planning board and go through the whole process of getting the lot line moved over 15 feet just so we can say it's not a 1 foot setback. And I don't feel comfortable saying that I want to die on that hill. I don't think it makes a difference to me, and I don't realistically think it makes a difference to anyone that's going to live there, whether that line has moved 15 feet or not. And so, to me, this is actually a pretty easy yes. I really don't, like all the concerns are legitimate, but also every outcome here is better than what exists currently, and that to me is what is important.
And I'm not saying that the 1 foot, that I would die on that hill tonight on this, and I'm not saying that I don't think it's a great project. I'm not saying that I don't think it wouldn't look beautiful, but I think it is unfortunate that I feel like questions and concerns are being pushed aside because other people are on a deadline. And we have no control over when people come to the zoning board. That is completely up to the applicant. So I don't like that. I feel like this is a vote with a hand tied behind my back, because I don't think the concerns are unreasonable. So it's not the project, and this is not Attorney Vaughn. You'd probably be the one spot where I wouldn't die on the 1 foot, but the other concerns outweigh that. But apparently there is nothing that can be done about that since there is a deadline.
One of the things that I have intentionally tried to do as chair of this board is to reduce the number of times that we bring people back. And the reason for that, beyond funding deadlines like this, is just that we have historically created extra red tape and extra steps that we make people go through for things that don't necessarily change the outcome of our decision. If it is something that is important enough that it changes a thumbs up to a thumbs down or a thumbs down to a thumbs up, then I'm open to continuing it. But I don't love the idea of continuing meetings so that we feel better about a decision that we were going to make anyway.
So, what are the outstanding questions you have? Mostly about fire and ambulance?
One, and I don't recall all of them, I don't know if the one abutter feels, because it seemed like she was on a 3-minute deadline and she didn't want to reiterate. But I don't know.
That's why I read off her questions. So that
Okay,
we at least got those.
I don't know, because that was done after. I don't know if she feels satisfied, and I don't know if those questions and the answer to them raised other ones. I still don't like the fact that at the end of the day, for me personally, I feel I have to live with these decisions. These decisions matter to me. I am still haunted by some of them because of the impact I have made on people in this town. And so, yes, the concern of a fire truck and an ambulance, that matters to me. The fact of, if this is a private way, what can be done about controlling the parking? Maybe nothing's been done about it because guess what? No one lived down there. So nobody was making a big enough issue. Those are some of my things. It's not a matter of the applicant paying to fix the road. I'm sure the plow driver would appreciate that. Yeah. My concern becomes, can you get a fire truck down there? Can you get an ambulance down there? Can you get them out? And yes, that is a question that matters to me on the decision. Because I'm not going to sit here and put a condition because of where I stand of sprinklers, because that's an added cost. That if the fire chief comes back and says, no, we're good, or you're right, we're not good, the town's going to address it, then it's saving them money. So why put more of a cost that doesn't necessarily need to be there?
Well, we could put in. that
I'm
the
not putting anything.
No, I'm just saying, we could put that the fire department doesn't feel like the trucks can get up the street, then they have to sprinkle the buildings. It's just, I mean.
Well, and they will say that anyways.
We're just making that up, because usually access and sprinklers are two different things anyways. So.
But I think the applicant's
Haverhill
fine
might have
based
said
on
okay,
how everybody
but
else
who knows what Northampton
so,
would say.
with or without me.
We hate to leave you on that hill.
I'm okay. I am on this hill plenty of times by myself.
you on an
Attorney
island.
Vaughn knows that I have my
you on an
picnic
I guess,
basket.
I guess the access in the road is what it is.
And like I
There's-
said-
there's not really room to change it.
Right.
So, I've certainly seen fire trucks get into a lot of places when they have to. I've seen them push cars aside, I've seen them they get where they need to go if there's an emergency. When they're done, backing out may be a pain in the ass, but if they're needed, they'll get there. And it's not a very long road. If they have to park on Water Street, they'll park on Water Street and get up there.
And
So,
I hope to God
Eh,
that
but-
that's
but-
never a situation that's needed.
no, right. Now, if they will tell you it should be better. I know the answer is that they would say they need better access, so it's obvious.
I'm okay being on this hill by myself.
But I don't think there's a solution. You know, either, if you want the fire department to say, hey, yeah, that's perfect access, it's all good, we're not gonna hear that. And if you don't hear that, what are you gonna say? Yes or no? We do nothing? Or we
Doesn't matter at
or we-
this
Or
point.
we rebuild the single families, you know, whatever, but,
So, Scott, correct me if I'm wrong, right? So the plans come in, fire department has to sign off on them.
Yeah, they will review them and sign off on them and make any determinations they may need to make.
Will they take the road into consideration at that point?
Oh, yeah, I know they'll definitely consider their ability to fight a fire. It's not uncommon, there are other properties out there where access is tricky.
Right.
And they
So-
make decisions on how best to deal with it.
And if at that point they decide that the houses should be sprinkled, would they make
They
that?
have the full authority to do so, yes.
Right, at the time of permitting?
Yep.
So we don't really need to be overly concerned with that?
No, they'll make their own judgments and criteria based on a lot of factors, and if they feel that's the only solution to provide proper coverage, they will demand it and require it under their own Chapter 527.
Okay.
All right. We are at 11 o'clock almost. Mr.
Okay.
Killalay, would you like to lead us in the ritual?
Yes, so with the special permit, I don't think we have to reference a plan, but with the variance, are we talking about just referencing the site plan or the architecturals as well?
I would just do the site plan. I think the architecturals are so standardized at this point that I don't think there's even if they wanted to change them, there wouldn't be an opportunity really. So the site plans by Andover
Well-
Consultants, Inc.
Okay.
July 15th for, let's see, for 16. It's
Yeah, and I
July
sort of
15th.
I pulled them all out, so I
Yeah,
have
okay.
easy access to them.
Okay, yeah, they're all July 15th.
I just didn't know if, without the, if we don't specifically say this architecture, either they come in with a three-story building, something like that.
I mean, well, it is a three-story building, but
Well,
it's got a third story, but it can't be more than 35 feet anyway.
okay.
Chairman?
Yes, sir.
Are you going to be putting any conditions on this?
I don't think we are.
Okay.
Do you have a
The only one I
recommendation?
might request you consider is for outdoor flood lighting, they consider
Okay.
dark sky design standards.
Okay.
Because we commonly get lots of complaints about the neighbor's floodlights, and if you don't consider the action of dark sky or aiming them down, we don't have a lot of power once they're in place to say, tone it down, don't shine it in your neighbor's yard, and I get lots of complaints about that, so.
Okay.
They can consider that up front.
I can't ask the applicant that right now, but I'm going to, without looking at their faces, I'm going to assume for the moment that among all the other things that we've asked of them, that one's probably the more reasonable one,
Yeah.
so I'm guessing that one's okay.
Is that
Yeah, we
is
got
that a building code issue or a zoning code?
That is not technically any of them, but that's a common planning board standard for lighting. They consider dark sky standards for limiting
Yeah,
the amount
no,
of lumens at the property line.
Right.
Floodlights are a common complaint. I get lots all the time.
What we have to be a little careful about the wording because we've got the new standard for wording that we may not even be able to require it in the first place, but that we can try
Well,
using Ms. Murray's
Well, it was
suggested wording.
but the conditions was about variances. We could apply it to the special permit, right?
I'm not sure it applies to anything, but maybe you're right.
I forget.
This is
I also
fun.
wanted you to say it out loud so the applicant heard me too.
Yes. This is a fun world we live in now, where we have to figure out what the actual zoning rules are as we go through this. I have the brief. Let's see what-
Yeah.
Actually, I don't. It's not in the original brief. Conditioning. There we go. Yeah, it's a variance.
I'm sorry.
Okay, so we will put it on the special permit and hope that that gets us enough. All right.
Okay. How do we want to word that one? Because I'm going to say it a bunch of times.
Conditioned on the
Exterior lighting,
application of dark sky standards for exterior lighting. Is that a good? Okay.
Sorry,
We had 6 things we got to vote on?
We got 6 things we got to vote on.
6 readings.
Just making sure.
Voluntarily re-up for this position? I mean,
We're not gonna let vote.
All I'm saying is that maybe we should each be bringing a case of beer next time.
All right. So, I'll make a motion to approve a special permit pursuant, wait a minute, I have to, excuse me. I have to reference which
Which unit?
we're talking to. So,
Yes.
but I usually don't read this section.
No, usually you say 14 Browns Court, and then
Yeah.
you say a special permit.
Okay, regarding 14 Browns Court, I make a motion to approve a special permit pursuant to Town of North Andover zoning bylaws, Section 195-3N, 1B, 195-4, 3N, 4, and 195-10.7 to raise an existing structure and construct a two-family dwelling. And we will place a condition on the approval that the application of dark sky standards for exterior lighting is applied.
All right, Mr. Hatchie,
Aye.
Mr. Testa.
You want a second?
Oh, somebody needs a second, sorry.
A second.
All right, Mr. Hatchie.
Aye.
Mr. Testa.
Aye.
Ms. Jacobs.
No.
Mr. Killalay.
Yes.
And I am a yes.
Okay. Regarding 14 Browns Court, I'll make a motion to approve a variance pursuant to Town of North Andover zoning bylaws, Section 195-7.2A and 195-7.3A and B, and Table 2 dimensional requirements for front setback, one side setback, lot size and frontage in the R4 zoning district for the purposes of constructing a two-family dwelling. Specifically, applicant has requested a front setback needing a relief variance of 10.8 feet. The front setback proposed is 19.2 feet, and the front setback required per Table 2 is 30 feet. A side setback needing a relief variance of 4.9 feet. The side setback proposed is 10.1 feet, and the side setback required per Table 2 is 15 feet. Lot size needing a relief variance of 6,632 square feet. The lot size is 5,868 square feet, and the lot size required per Table 2 is 12,500 square feet. And a frontage needing a relief variance of 34.95 feet. The frontage proposed is 65.06 feet, and the frontage per Table 2 is 100 feet. And we will reference the plan of land by Andover Consultants, Inc., dated with April 18th, 2025, with a revision date of July 15th, 2026.
Mr. Ginsburg. Oh, yeah, we need a second. Yeah. Mr. Ginsburg.
Aye.
Mr. Testa.
Aye.
Ms. Jacobs.
No.
Mr. Killalay.
Yes.
And I am an aye. All right, next one.
Okay, 16 Browns Court. Make a motion to approve a special permit pursuant to Town of North Andover zoning bylaws, Section 195-3N1B, 195-4, 3, and 4, and 195-10.7 to raise an existing structure and construct a two-family dwelling with the condition that the application of dark sky standards for exterior lighting will be applied.
Second.
Mr. Hatchie?
Aye.
Mr. Testa?
Aye.
Ms. Jacobs?
No.
Mr. Killalay.
Yes.
And I am an aye.
Okay. I make a motion to approve a variance for 16 Browns Court pursuant to Town of North Andover zoning bylaws, Section 195-7.2A and 195-7.3A and B, and Table 2 dimensional requirements for front side setback, one side setback, lot size, and frontage in the R4 zoning district for the purposes of constructing a two-family dwelling. Specifically, applicant has requested a front setback needing a relief variance of 11.1 feet. The front setback proposed is 18.9 feet, and the front setback required per Table 2 is 30 feet. A side setback needing a relief variance of 14.0 feet. The side setback proposed is 1.0 feet, and the side setback required per Table 2 is 15 feet. Lot size needing a relief variance of 7,202 square feet. The lot size is 5,298 square feet, and the lot size required per Table 2 is 12,500 square feet, and a frontage needing a relief variance of 40 feet. The frontage proposed is 60 feet, and the frontage per Table 2 is 100 feet. And we will reference the plan of land by Andover Consultants, Inc., dated April 18th, 2025, with a revision date of July 15th, 2026.
Do I hear a second?
Second.
All right, Mr. Ginsburg.
Aye.
Mr. Testa.
Aye.
Ms. Jacobs.
No.
Mr. Killalay.
Yes.
And I am an aye.
Okay, make a motion to approve a special permit for 20 Browns Court pursuant to Town of North Andover zoning bylaws, Section 195-3N1B, 195-4, 3, and 4, and 195-10.7 to construct a new two-family dwelling with the condition that the application of dark sky standards for exterior lighting will be applied.
Do I have a second?
Second.
Mr. Hatchie.
Aye.
Mr. Testa.
Aye.
Ms. Jacobs.
No.
Mr. Killalay.
Sure.
And I am an aye. Can we get a little bit more definitive than sure?
Yes.
There we go.
Okay, make a motion to approve a variance at 20 Browns Court pursuant to Town of North Andover zoning bylaw, Section 195-7.2A and 195-7.3A and C, and Table 2 dimensional requirements for front setback, rear setback, lot size, and frontage in the R4 zoning district for the purposes of constructing a two-family dwelling. Specifically, applicant has requested a front setback needing a relief variance of 17.1 feet. The front setback proposed is 12.9 feet, and the front setback required per Table 2 is 30 feet. A rear setback needing a relief variance of 16.1 feet. The rear setback proposed is 23.9 feet, and the rear setback required per Table 2 is 30 feet. Lot size needing a relief variance of 2,326 square feet. The lot size is 10,174 square feet, and the lot size required per Table 2 is 12,500 square feet, and a frontage needing a relief variance of 60.99 feet. The frontage proposed is 39.01 feet, and the frontage per table 2 is 100 feet. We will also reference the plot plan by Andover Consultants, Inc., dated April 18th, 2025, with a revision date of July 15th, 2026.
Do I have a second?
A second.
Mr. Ginsburg?
Aye.
Mr. Testa?
Aye.
Ms. Jacobs?
No.
Mr. Killalay?
Aye.
And I am an aye. We are done.
Thank you.
All right, thank you. So we have one more item on the agenda, which is that when we had this application for a minor modification, we did not actually have an official form for them to fill out. And so this is something that we have drafted in the past but never actually approved. Do we have a motion to approve this form for use?
I'll move that we approve this form
Wait a
for
minute.
use for modification.
I never seen no traps. I never seen, because I can look right across and see that tear down house. I didn't see no traps.
So this is the form that we just saw, right?
Yes, this is the form that we just used.
So we're asking if this is going to be the form going forward?
Exactly. So we sort of did it on an unofficial basis for this round because we didn't have anything for them to fill out at all. And so,
I mean, if I'm gonna be nitpicky, I would just say previously approved decision number and date. But,
previously approved decision number, date. Okay, I can
That's-
modify, and with those modifications, do we have do we have a motion to accept?
I haven't seen it, so I'll let somebody else.
I can post. We can table this for another meeting.
yeah.
This one
Let
I
me
don't
just-
feel bad about tabling.
Well, I feel bad about making a motion without really looking at it.
I know the second board.
Hmm?
So you know what? We had the problem of figuring out how we were supposed to read this in. I guess we
Yeah.
decided how to read in based off of the agenda, which is different than reading in from a public notice.
well,
I don't know. I don't know if they might just. I don't
would
know.
it be helpful to
Looks
you
fine.
if there was a paragraph at the top that was kind of left
Like
with
the
blanks?
agenda or something?
Well, that was
Yeah.
left with blanks so that the applicant had to fill in, and then that paragraph is what you would read?
Yeah.
Okay,
I
I can
think so.
redraft that, so we can postpone.
Does that
this
make
with-
sense?
Yeah.
Um,
And then that would be the same thing they take and put in the agenda so that they have that for the agenda, right?
All right,
It comes
so-
out when it's real stakeholders, you know, it's paying attention.
So,
The guy who has to read it.
so one last thing is, Mr. Vanderwall had asked me to close out items with this, and I have not done that all this meeting. You mentioned it at the last one. I'm going to say it now for the record, but I will promise to do better in actually ending the items with
Just
it.
gives them a clear understanding when they walk away, especially the owners.
Right.
What comes next, because they all march down, okay, can I have my permit? And I go, wait.
Right. So with that, just for the public record, and again, I will try to do it in the moment better, is that the board has 14 days to write the decision, after which it enters the 20-day appeals period by law. At the end of the 20 days, you must contact the town clerk to get a copy of the decision and release of the appeals period. That decision must be taken to the registry of deeds, whereupon it should be recorded. The original of that recorded decision must be taken to Terry McNeil at the zoning department. She will then upload it to the permit number so that the building department can issue the building permit. If you have any additional questions, please reach out to the board secretary, Terry McNeil, at Town Hall.
Does that apply to variance and special permits?
It applies to any sort of permit we have to issue from any sort of zoning relief you provide. So variances, special permits, findings, whatever it is, I can't issue a permit until it's legally approved by recording at the registry. It doesn't come into existence until it's recorded technically.
Yeah. And I think this is a useful thing to be doing as a public service so that everybody, including folks who may want to appeal, know that they can do that.
Right.
So, All right, with that, do we have a motion to adjourn?
I make a motion to adjourn.
All in favor?
Aye.
Aye.
And I am an aye. Thank you.